Compelling circumstances. Section 9 application, e-filing done. We serve upon the respondent, challenging a termination of a registered lease for 99 years. Right after it was served, we receive a notice from the respondent to the GM asking for possession to be taken this Wednesday at 12:34. We have to, e-filing has been done. We'll be getting the number by 11 o'clock, AP number.
Have you issued a 21 notice?
21 notice we have issued today in court. Today in course of the day will be issued.
Why didn't you issue it if it was so urgent?
Because a decision of January communicated in June, then we got to know they were doing something. We immediately Section 9 application.
There was a dispute. If there was a dispute, you should have issued a notice earlier. What was stopping you?
This for urgent interim relief, my lord, because if the property is taken away, possession by police, the GM is being written that you arrange for police and take possession on 5th of August at 12:30 p.m. This is after service of the Section 9 application.
The dispute must have arisen long back.
But we have received in June. The decision is of January, communicated in June.
So why didn't you issue a decision of January communicated in June?
In June.
So from June to August, what were you doing?
We have 27th of July, it was affirmed and filed, this application.
Why didn't you issue a 21 notice if you really wanted a resolution to your dispute?
Today, within 30 minutes, the notice will be issued. Within 30 minutes.
It was so urgent, you should have issued a notice. What was stopping you from June till August?
AP number we are going to get, kindly grant leave to move either at 2 p.m. or tomorrow at 10:30, my lord. Because Wednesday, my lord, the property is going to be.
I am absolutely against a person who comes to the court without issuing a 21 notice.
Well, the notice should
it means there's nothing urgent about it.
No, we are undertaking to do it within the next half an hour's time.
Why should I even entertain something like this?
Well, it will be done within half an hour before, my lord. We move it before your lordship, the notice will be.
If you can wait for 3 months, you can wait for next 3 years.
Well, the property will be taken away. This is entirely an illegal way of taking away. I mean, possession, registered lease.
Then if in June you were communicated with a decision which was taken in January, why didn't you issue a 21 notice and go before the learned arbitrator?
Well, the notice should have been issued earlier. Well,
why should I entertain if it is so urgent?
Well, the urgency is, well, kindly seize this notice.
I don't care.
After service of section.
Sorry, sir.
Well, we are going to.
If you are backpedaling with the government, it's not my problem.
Well, I kindly appreciate. This is we are coming for an urgent interim relief. Well, the reason after service.
I hold it's not urgent. If you have not issued a 21 notice, it's not urgent. There's no urgency.
Well, before we move, my lord, the notice will be issued, my lord. Well, kindly grants me leave to move it, my lord. If not to 2 p.m. by tomorrow, my lord, with short service. We'll give the number, my lord. The notice will be grateful, my lord. Kindly grants leave, my lord.
Lordship, may I mention items 779 and 780 of the monthly list, Lordship?
Wait.
Lordship.
Tomorrow will serve, my lord, also the advocate on record of this case.
Grateful,
my lord. The notice will be issued to you.
No problem.
May I have my lords kindly to mention a section 11 application, lordship. I have served the notice on the other side. Lordship, may it appear on the daily list on 7th August.
It's not in the list.
Not in the list, your lordship.
It's in the monthly list.
No, lordship. Not in
the list.
Not in the list, lordship.
My lord, may I mention?
My lord, may I be permitted?
Just a minute. Yes.
My lord, may I be permitted to mention item number 87 and 88 of the monthly list? My lord, these are the unilateral appointment matters.
Who's on the other side?
My lord.
Who's on the other side?
My lord, Sina and company is the other side. My lord, I shall inform them. My lord.
Inform them. Don't mention without them.
My lord.
My lord.
Okay.
Inform them first.
Lord, bank guarantee, my lord, invocation. My lord, the letter notice of invocation is 11 July 2026. My lord, the bank guarantee is valid till the 7th of August 2026. My lord, they say that if I don't renew it, they will proceed to, my lord, invoke it. My lord, the contract has been performed. Only, my lord, some reconciliation of accounts was remaining, my lord. And this was an advance bank guarantee. So it's outlived its purpose. Also conditional bank guarantee, my lord. 7th August is, my lord, the threatened date of invocation.
So what is it? So section 9?
Section 9, my lord.
What about 21? Have you issued?
No, my lord, not yet been issued, my lord. The notice of invocation.
I'm not getting it.
My lord, 11 July is the notice, my lord.
This practice has to change.
My lord, we will immediately issue the notice.
This practice has to change. Issue a 21 if there's so much urgency in your case.
That will be done, my lord. But kindly see, my lord.
This is absolutely not done.
My lord, the tribunal
Come
would
at
not
the
be
last
constituted
minute.
even if we issued the section
That's the
2021
problem.
notice. My
Why
lord, the
didn't you
30-day
issue
period
it?
would not
Why
expire.
didn't you issue it earlier?
No, my lord,
When did the dispute arose?
my lord, the notice asking me to renew or threatening invocation is
When
11th.
did the dispute arose?
My lord, the disputes
Long
with
back.
regard to reconciliation of bills is long pending, but the
So why
threat,
didn't you issue a 21 when the reconciliation was taking place?
because my lord, they were still, they had not refused to reconcile. That is what I'm trying to say. The threatening invocation, my lord, letter is of 11th July. Even if I issued the 21 notice, my lord, 30 days would not have elapsed before the, my lord, the expiry of the bank guarantee and the invocation. That is the urgency I come with, my lord.
Stop.
But we appreciate what is falling from your lordship, my lord. We will take, my lord, adequate measures henceforth, my lord. But in this case, my lord,
You've
even
already
if
filed it.
I beg your pardon,
It's
my lord,
already filed.
31st, my lord, of this month it is filed.
Give it. Give the number.
My lord.
My lord,
Great.
I'd beg to mention an item which is there in the list, my lords, item 235, my lords. My lords, this is a matter between Steel Authority and McNally Bharat, my lords. McNally Bharat is the matter, my lords, is the client which is...
What has happened? What do you
my lords,
want?
what has happened is there's a section 34 which is filed, my lords. Award is in our favor, my lords. I'm requiring an upgradation in the list, my lords, if this matter could be taken up. Actually, my lords, what has happened is this company is...
Award of which year?
My lords, award of 2024, my lords. So, my lords, the urgency is, my lords, we are a company which has recently come out of CIRP, my lords. We require, my lords, it has reached a point, my lords, this was one of the assets that the company had, my lords, when the SRA took over the company, my lords. This is, now it's reached a point, my lords, the company is actually crippling because it does not have assets. This is an award which is in our favor, my lords. The sale authority has also deposited about 30 odd crores before the registry of
You
the court.
withdraw it.
There's 15 odd crores in cash and 15 in BG, Malods.
Right.
Malods, we'll have to deposit bank guarantee to withdraw, Malods. That may be problematic because, Malods, we are in a situation, Malods. It's a very short matter, Malods. On the point of one claim, Malods, has to be heard, Malods. It's actually a little urgent. We've informed the other side, Malods, if...
You withdraw the bank guarantee right now and we'll see the 34. It's a 24 award. What's the urgency?
Malod, the urgency is, Malod, strangely, this company will see a second light of CRP, Malod, if we are not been able to arrange funds, Malod. It's been more than...
Funds are already there. You withdraw it. Move an application, withdraw the funds.
Malod, but Malod, depositing a BG would be difficult, Malod, at this stage, Malod. That's hence, Malod, we want the matter to be decided on its merit, Malod.
I don't know. We are hearing, ये कब रखा हम लोगों ने 34? Give it, we'll see.
Grateful.
May I have your Lordship's kind leave to mention two Section 34 applications arising from the same award. Lordship was kind enough to take one of the applications the previous date and had passed directions that the application might be listed on the commercial division. It was originally the original side. But we are praying if the connected matter could also appear on the list, and even if that could be shifted to the commercial division, then the both matters can be heard together. 234s arising from the same award.
ये to be mentioned में रख के फिर एक order pass करके कर दें.
My lord, may I permit to mention
It a non-commercial action. Great.
Epicom 619 of 2026. I am praying for inclusion as motion. The matter is section
What
11.
is it? Section 11.
Yeah, so
In-
section 21 notice already issued.
Section 21 issued. What is, have you filed it? Section
Yes,
11.
yes.
It's already there in the list.
No.
Give it.
My lord, may I mention this execution matter?
What is this?
Yep.
Is this the way to mention? Sorry, no. No, this is not the way to mention. This is not the way to mention.
My lord, may I mention this execution matter for withdraw? My lord, kindly.
Mention this matter for inclusion. Section 34 application.
Section 34, it's in the list or not in the list?
Not in the list.
ये list में तो डालो कम से कम.
My lord, kindly allow me to mention a matter. This is a section 36 and a section 34 application. They are appearing as item number 138 and 326 of the monthly list. My lord, the award has been granted in my favor. The judgment letter has taken adjournment on several occasions, my lord. I am humbly praying for upgradation of the matter.
We'll see. दे दो. ये
Obliged.
May I, Lordship, now?
Yes.
Lordship, a bizarre fraud has been played on this court
Your petition in person.
by the petitioner in item number 779 and 7 monthly list.
I can't hear
Lordship,
you,
I am
sir.
the respondent in person, Lordship.
I can't hear you, sir.
I want to place before this court that a bizarre fraud has been played on this court in item number 779 and 780.
Yes,
Lordship.
I can't hear you. Your connection is not good,
Lordship,
Mr. Agarwal.
it's item 7.
Mr. Agarwal, your connection
Lordship,
is not good. So come in
Lordship,
first and mention it.
Lordship, may I come at 2 and mention Lordship? Kindly.
No, you can't come at 12 and mention. Mention when the mentioning is done. Yes.
Lordship, am I audible now, Lordship?
No, you're not. Take out the matters.
Listed matter, new motion, section 29, item number 1.
My lord, this is my 29 application, my lord. On the last occasion, my lord had gave a liberty to file to service, make a service once again, my lord. I have done that, my lord. I am seeking for alternative service because the service is not complete, my lord.
Mr. Huck, you have to find these people's address. You know, they are all
My
your
lord, we are
clients.
trying, our client is also trying personally visiting these places, my lord. But we have no option but to do alternative service, my lord. We have tried thrice, my lord.
Take down learned counsel for the petitioner states that despite best efforts, he has been unable to serve upon the respondent. He prays for paper publication, substituted service in the form of paper publication. 3 attempts had already been made by the petitioner who has been unable to serve upon the respondent. This court allows the substituted service in the form of a paper publication, one in the English daily and one in the vernacular, within a period of
15 days, my lord.
2 weeks. List after 4 weeks.
Grateful, my lord. By 15 days.
Not 2.
Matter is being settled, my lord.
My lord, the draft settlement agreement we have received yesterday, my lord. 4 weeks time, my lord, because it's in Burnpur, my lord, where it has to be signed, and I am to receive certain payments. I'm letting off, my lord, some of part of my claim, and I'm settling it at my lord lesser amount. My lord kindly keeps it 7th
Not
of
that
September.
far. Why is 4 weeks? Why not 2 weeks?
My lord,
My lord, I am told that there are, my lord, different, my lord, officers of sale, my lord, the respondent who would be signing the document.
Learned counsel for the parties. Learned counsel for the parties submit that the matter has been amicably settled between the parties and they have exchanged a draft settlement deed. They pay for an adjournment for a period of 4 weeks. Let this matter be listed after
Next monthly list would, my lord, suffice.
after 5 weeks.
Great. Great. I'm taking it.
3.
My lord, item number 3, I'm for the petitioner, my lord. My lord, as per instruction, my lord, kindly keep this matter, my lord, next Monday, my lord.
Lord, next Monday.
Why, what happened?
I have come. They could have
What
informed
happened?
us.
My lord, the instructions, they are discussed with some instructions that if we withdraw this matter, but right now we don't have any instructions. Kindly keep it next Monday, my lord.
Councils are coming from outside. You should have informed. You should have informed them also. Yes.
We need some more time.
Should have informed the other side that you are going to take time. Yes, Mr. Sharma.
Lord, then, Lord, Lord, then Lordship may have it after 15th of August, not before that. Any Monday after 15th.
17th. We'll have it on the 17th.
My friend says 24th, Lord. I have no difficulty.
I'm sure they also don't have any difficulty in a longer date, I guess. When do you want? 17th or 24th?
24th, 25th, my lord, please.
25th is non-commercial day, madam. Can't happen.
26th, my lord.
26th, yes. 26th?
26th.
Your lordship, kindly keep it on 17th of August.
17th, they have some
might be a
difficulty.
holiday, your lordship.
Why?
26th.
26th?
26th, my lord.
All right, 26.
Please, read.
Learned counsel for the petitioner seeks an adjournment on the ground that they are unable to get the instruction from the client. That's the ground?
Your Lordship,
Unable to get the instruction, right?
Yes.
Your
Need
Lordship,
more
we need some more time to get the instruction.
Learned counsel for the petitioner states that he needs some more time to get instruction from his client. To seek instruction from his client, he prays for an adjournment. Let this matter be listed on 27th.
And if on 26 they want date, my lord, they can inform us.
Your Lordship.
Yeah, I'll be great. Great.
No, 26. Sorry, 26. 26.
26, my
26.
lord.
Your Lordship, in the meantime, if we get instruction of withdrawing, we will mention and we will withdraw it, Your Lordship.
You can do that.
Court.
For Lordship, on the last occasion, Lordship directed to paper publication, Lordship. So, my Lord, give me a 2 weeks time to comply the last order, my Lord.
Learned counsel for the petitioner seeks and is granted 3 weeks time to comply with the order dated 13 July 2026. Just after 4 weeks.
Deeply obliged.
Five.
Please, my lord.
Yes.
Unless my learned friend has some serious objections, the extension can be granted.
Objecting to the extension, my lord.
Yes. What is the objection? The file your reply.
My lord, no directions as of yet, my lord. I like to file a
What is,
reply.
what is the
Lord,
objection?
I'm satisfied, my lord. Two different proceedings, my lord. Item number 5 and 6
Yes.
arising between the same parties. Arbitration invoked in the year 2022. Lord,
2022. Yes.
My lord, at the initial stage, my lord, an application was made at behest of the respondent for analogous hearing, my lord. Because two are identical on a particular work site, a tender was floated by the respondent for supply of material and for erection of a PV building. It's a pre-engineered building, my lord. My lord, that application was refused upon observing that it is not the right stage and at the appropriate stage it will be considered. And Lord, subsequent thereto, it was carried before this honorable court by way of a civil revision. The honorable court, my lord, by observing that since the arbitrator has already observed that it will be considered the appropriate stage, this honorable court please not to intervene with the order passed. Now, my lord, in the amidst of all these things, the other proceedings, item number 6, the proceeding was over, the hearing was concluded way back in 2024, December 2024. My lord, we are standing on July 26th. Well, on the pretext of passing an order, a conjoint order, the learned arbitrator was pleased to withhold that order since 2024 in the other matter, that is item number 6, my lord. So far as the present item number 5 is concerned, my lord, it is at a stage where the claimant has concluded its argument and the respondent is supposed to start, my lord. At this juncture, the arbitrator has, if I may please to take your lordship to the order passed by the learned arbitrator, my lord. It's at page 94 of the item number 5, my lord. Well,
Yes.
going beyond, if your lordship be pleased to take second paragraph of page number 94, my lord, so far as the payment of certain amounts toward further fee of the tribunal as per last direction of the order dated such and such is concerned, the claimant has given their no objections. However, my lord, at that point in time, we have not received instructions, but my clear instructions are that the arbitrator has already been directed to charge in terms of schedule 4, my lord. And since the schedule 4 limit has already been reached and the entire payment has been made, my client is not ready and willing to proceed further with further payments, my lord. My lord, that is the primary ground of objections, my lord. My lord, so far as the scope of 29A, may I rely on a copy of a judgment, my lord, passed by Supreme Court, my lord, if I may allow to hand over, my lord.
Which is this judgment?
I'm sending it over WhatsApp. Just give me WhatsApp.
Yes.
My lord, similar circumstances arises in this matter, my lord. If your lordship be pleased to take paragraph 7, my lord. submissions, learned counsel for the appellant submitted that the sole arbitrator acted in contravention of the initial order of appointment dated such and charged the fee and expenses in excess of the fourth schedule. It is further submitted that the sole arbitrator also violated the directions issued in the order dated such and such passed by the High Court. It is contended the High Court ought to have appreciated the power to substitute of an arbitrator is wider under Section 29A6. My lord, the Delhi High Court, based on an application under 29A45, my lord, has already extended the mandate of the learned arbitrator. Challenging the same, this matter went down to Supreme Court, my lord, and upon analyzing, my lord, paragraph 10, my lord, at internal page 4, the Supreme Court proceed to held that Section 29A has been held to be a remedial in nature and is made applicable to all pending arbitral proceeding. And thereafter, my lord, if I may place the relevant portion at paragraph 12 at page 5, we are conscious of the fact that the two-judge bench of this court had interpreted the word terminate in Section 29A4.
Wait a minute. Where are you reading? Sorry, 10?
My lord, paragraph 12, my lord, at internal page 5.
Yes.
The lordship got it, my lord? We are conscious of the fact that the two-judge bench of this court has interpreted the word terminate in Section 29A4 while dealing with an issue whether an application for extension for time for passing the arbitral award is maintainable even after the expiry of 12 months or extended 6 months period as the case may be. It has been held that on expiry of the initial period of 6 months and extended period of 6 months, the arbitral tribunal becomes functions officio, but in not absolute terms. It has further been held that the termination of arbitral mandate is conditional upon the filing of an application for extension and cannot be treated termination stricto sensu. It has been held that the legislature, by using the word terminate, intends to affirm the principle of party autonomy. However, the fact remains that expiry of an initial period or extended period, the arbitrator cannot proceed with the arbitration proceeding and is mandate terminated subject to an order which may be passed by a court in the proceeding under 29A4, my lord. And thereafter, my lord, if I come to paragraph 13, starting from the three last line, my lord, that paragraph 13 starts with the word therefore. The order dated such and such does not have any impact on the decision of the petition under 29A of the Act filed by the applicants. The substitution of a sole arbitrator is warranted when his mandate ceases to exist to effectuate the object of the Act, which mandates expeditious resolution of the dispute. In view of the statutory scheme and undisputed factual position, we are satisfied that the case warranted the exercise of jurisdiction under 29A6. The High Court erred in granting the extension when the mandate of the sole arbitrator ceased to exist, my lord. My lord, on earlier occasion, my lord, this is the third 29A, my lord. In between January 2024 to January 2025 to April 2025, no proceeding took place. The claimant chose to abandon the proceeding. At that juncture, on December 2025, the respondent came up before this honorable court seeking extension, which my claimant never objected to. My lord, there is a specific direction in the other item, in the other matter, my lord, to pass an order because the hearing has concluded in the way in December 2024 to pass an order. Even after the extended period of 6 months, the arbitrator chose not to pass the award in terms of Section 29, my lord. And that is my limited ground of objections. If I may, if your lordship be permit, then I can come up with opposition, my lord.
No. Take down. You have to say something. Let him
Yes,
file
Raja,
it.
insofar as the limited grounds taken by my learned friend, firstly, on the ground that the arbitrator is saying that you pay certain extra remuneration,
Okay.
I have no objection. Rather, if
Mr.
the
Berry, if he has taken the money.
31 hearings, my lords, time and again the adjournments have been taken by the other side. Twice they have approached the Honorable High
Let him
Court.
file his reply. We'll see
Yes.
that. Learned counsel for the petitioner has moved the present application seeking under Section 29A4 seeking extension of the mandate of the arbitral tribunal. Full stop. Learned counsel for the respondent objects to the present application on the ground that the arbitrator had already got his fees in terms of the fourth schedule of the Act, and that the arbitrator seeking further remuneration is contrary to the Act. Full stop. He states that he seeks and is granted 3 weeks. 3 weeks time to file his affidavit in opposition in both the matters.
In both the matters.
He's seeking more money in both the matters or only one?
Well, remuneration.
May I just make one submission? Let them furnish that they have paid fully.
They have
Because
to.
if they want to take a wrong stand before the Honorable High Court,
Filing the
they'll
affidavit.
face the
I will,
consequences.
my lord. Kindly.
They'll face the consequences then.
That's why I've recorded it.
Yes,
Let
my lord.
us file it.
My lord, kindly record my submission that we have paid
This is an item?
item 5, my lord, and 6.
No. You have paid the remuneration in item
In
5.
both the matters, my lord.
This contention is for both the matters?
My lord, the arbitrator has only asked in respect of item number 5, the excess remuneration, my
So
lord.
this goes in item number 5. He seeks and is granted 3 weeks time to file his affidavit in opposition. Reply to the same if any within 1 week thereafter. List after 4 weeks. And in item 6?
And item 6, my lord, the proceedings to concluded on 17th of December 2024.
No, the application be final as well. So learned counsel for the respondent states that the proceedings in the present matter had concluded in the year December 2025. Since then,
2024, my lord.
2024. Since then, the learned arbitrator had failed to pass the award.
Even after the extended period in time.
Even after the extended period. He seeks and is granted liberty to file his affidavit in opposition within a period of 3 weeks. Reply to the same if any within 1 week thereafter. List after. वहाँ जहाँ लिखा है ना, has failed to file. On this ground, he states that the learned arbitrator has unduly delayed the proceedings before the tribunal. उसके बाद कर देना.
Let's maybe have a date on 7th of September.
Whenever it's after 4th or 7th of September. 7th of September.
Both the matters. Only great.
It's
Motion section 11 at now 7.
This is my application, Your Lordship, but respondent have already filed an suit which is pending before court number 23, Your Lordship. That matter is fixed on 19th of August this month.
Learned counsel for the petitioner submits that the proceedings which are pending before the coordinate bench of this court are listed on 19th of August. She prays for an adjournment to await the outcome of this proceeding. Let this matter be listed in the monthly list of September.
Monthly list of September. It's fixed in the.
Grateful, Lordship.
This goes in one matter or two matters? There are two.
One matter, Your
Seven
Lordship.
items.
Only one matter.
Eight.
I'm not responded.
In this matter, I am
Please
for the
kindly have a look
petitioner.
at the last order.
Yes.
There is a pending civil revision against the order under section 37, reversing the order, dismissing the 5 and 8. So that is, hearing is going on. It's even fixed today at 2:30 before another coordinate bench. So this will have to await the outcome of that.
Learned counsel for the parties submit that the revision petition is pending. Learned counsel for the parties submit that the revision petition is pending before the coordinate bench of this court and is listed today at 2:45. 2:30 p.m. Both the parties pray for an adjournment. Let this matter be listed in the monthly list of
September.
Obliged.
Grateful. I don't 9.
For the response.
Where's the affidavit?
The affidavits are done, they are supposed to file the reply.
Doing extension of filing the affidavit and reply, Your Lordship.
Affidavit आ चुके हैं? Where's your affidavit in opposition? It's not on record.
We have served, Lord.
Where is it? It's not in our record.
Lord, I'll take instructions, Lord. I project.
You have to give a copy to the court. Where is it?
Lord, on the next occasion, Lord, certain. I apologize, Lord, for the inconvenience, Lord.
Learned counsel for the respondent states that. Have you filed it in the registry? Where have you filed it?
Lord, my instruction is that you have filed it, Lord.
Where
Kindly,
have
Lord,
you
gives
filed?
me. Lord, kindly, Lord, gives me some time, Lord. I'll just take instructions, Lord.
Come back. Pass over.
Not 10.
Matter I am the receiver, my lord.
Yes.
Lordship, on the last occasion, there was a direction on the receiver to initiate fresh auction for the sale of the machine.
Only one bidder has come, my lord. I am paying for some time.
Learned counsel for the receiver seeks some more time to carry out the auction for sale of the machinery. Let this matter be listed after 4 weeks.
Grateful.
4 weeks.
নামগুলো দিয়ে যাবেন একটু ম্যাডাম একটা নামটা দেন 11.
For the respondents.
Lordship, I appear on behalf of the petitioner in this matter. Lordship, on the last occasion, the petitioners were granted time to file affidavit in reply. This is my affidavit in reply, Lordship. Lordship, I am led by Mr. Rohit Banerjee in this matter. He is not here. He is not present in court today. I am paying for a short, not today, Lordship.
Reply to the affidavit in opposition filed by the petitioner is taken on record.
And Lordship,
Learned
the
counsel for the petitioner prays for an adjournment on the ground that the main arguing counsel is indisposed. Let this matter be listed after 21,
Lordship, any day.
after 2 weeks. Reply to the reply to the
Wait for Lordship.
2 weeks. Not 12.
Your Lordship, kindly withdraw my section. Withdraw.
learned counsel for the petitioner seeks to withdraw the present petition with liberty to, what is it, section 9?
Yes.
Arbitral tribunal already constituted or what?
Your Lordship, on the point of jurisdiction, kindly withdraw.
With liberty to file appropriate proceedings in accordance with law. Can you go ahead? The learned counsel for the petitioner prays for present petition stands dismissed and withdrawn. Liberty as prayed for is granted.
No. 13.
Kindly withdraw.
Same ground.
14.
My lord, I am on behalf of the respondent.
14.
I'm on for the
Same.
claim, but I want to withdraw the proceedings.
All right. So 14 same.
Yes.
12, 13, 14 same. 15, madam.
Your Lordship, kindly withdraw.
Same. 15 also same.
Number. 16.
May it please your lordship, Lord, item 16. I do not know whether my learned, I think my learned friends are appearing because on the last day they did not appear, so I would have prayed for dismissal.
Lordship, this is my application under section 9, Your Lordship.
My Lord,
Petition-
before my learned friend starts, may I only indicate this, that I'll be praying for, my Lord, chance to file affidavits in the proceeding. My Lord, I'll indicate why, my Lord, once my learned friends, my Lord, make submission. Or if your Lordship, my Lord, permits me.
Let me hear, Mr.
My
Nam.
Lord, my Lord, my Lord.
Your Lordship, the petitioner is a developer, Your Lordship, and the respondent is the owner of the land, Your Lordship. In 2009, that is September 18, 2009, the petitioner and the respondent entered into a joint venture cum development agreement. Under the agreement, Your Lordship, the developer was to make construction on the said land at his own expense and pay rupees 20 lakhs to the owner of the land as security deposit. 5 lakhs was to be paid at the time of execution of the agreement.
You issued a 21.
Yes, Your Lordship. No, Your Lordship. Section 21 hasn't been issued. We've taken leave that we'll issue a section.
When will you issue? Why? When did the dispute arose? When
Your
did you
Lordship,
cancel the agreement?
Your Lordship,
There is no cancellation of the agreement. That's the point, my lord.
No, Your Lordship. They tried to terminate the agreement on October 27, 2025.
October 27. We are yet to come in 27.
October 27, 2025, Your Lordship.
25.
Yes, Your Lordship. That is at page 82.
After 2025, why you have not done anything? Why no
Your
section 21? What is the urgency in 9 then? Why should I entertain this in 9?
Your Lordship, we will.
What you are taking more than a year
Your Lordship,
to initiate arbitral proceedings?
No, Your Lordship. After
Why should this court get into section 9?
Your Lordship, after
There's
they,
so much urgency. You should have issued a 21 notice.
Your
Why
Lordship,
should we pass any order in 29?
in section 9, Your Lordship. Your Lordship, even in January
For
of
21, go before the arbitrator. File a
Your
7.
Lordship, in the meantime, Your
No
Lordship
urgency.
will protect me to the extent that
Nothing.
they will not
If
take
there is
any
urgency, I will. You should have issued a 21 notice. I would have understood. There's no ground. There's absolutely no ground.
Your Lordship will protect
Want to
me
carry on with this proceeding? He'll file his reply. You file your.
Your Lordship will protect me for
I'll do nothing.
2 weeks. In the meantime,
madam. If you would have issued a 21 notice, I could have understood that there is some urgency. You have done nothing. You have taken no steps. You have filed a section 9. Sorry, nothing. Nothing doing. This practice should stop.
Your Lordship, after the
Go
agreement
before the
was,
tribunal. Go before the tribunal.
Your Lordship, if I may indicate, Your Lordship, after the agreement was terminated in October 2025, we gave reply to that letter. Even in January 2026, we wrote to them. After we understood that they are trying to create a third-party right over the property, that is when Your Lordship, we approached this honorable court. And Your Lordship, we will issue a section 21 and we will go before the tribunal, Your Lordship. But Your Lordship will protect me in the meantime.
Nothing. Take down. The petitioner has filed the present application under Section 9 of the Arbitration and Conciliation Act, seeking an order restraining the respondent from dealing, dispossessing, alienating, or encumbering the property situated at.
Your Lordship, may I come?
Where's the property?
Your Lordship, the property is at.
We have 76 by 2A, Bidhan Sharani, my lord, it's at page. My lord, 20. Page 20, my lord, in the prayer they have described it, my lord.
The schedule is.
26/2A, Bidhan Sarani, Calcutta.
Your Lordship will allow me to come back.
Yes, come back.
Your Lordship will give me 2 days time. I'll come back with instructions and may I.
Not today.
My lord, tomorrow I'm in some difficulty, my lord. May it be placed then day after tomorrow, my lord.
Day after day after.
My lord, I'm very deeply obliged. Very deeply obliged.
Right.
And now 17.
My lord, this is a post-award section 9, my lords. Here, my lord, admittedly, the position is, my lord, that there is an award in favor of my assigner and also independently in my favor. It is a fact that, my lord, there is no stay on the award. And, my lord, I have taken steps in execution. But the point, my lord, which my lord had come up for, before the division bench, my lord, that in such a situation, what is the scope of the section 9? Lord, may I just place the division bench judgment, my lord, with your lordship's permission, because.
Satadru, section 9 petitions.
Give the copy. Kindly have, my lord. I appreciate my lord had indicated something, but so far as the Kerala proceeding is concerned, now the High Court has held in our favor. So their execution is proceeding. But my lord, kindly let me place this judgment after that, as my lord falls from your lordship.
Who's on the other side?
My lord, we have served, my lord. Affidavit of service is there, my lord. Additional data, affidavit of service. Supplementary affidavit of key. Supplementary to the other.
This is a supplementary affidavit also just to inform about the Kerala proceeding. Kindly have, my lord, the judgment of the division bench. What was the issue, my lord? Kindly have para 9 first. My lords, if I'm able to satisfy your lordship on the legal point, my lord, then because there is already an award. So kindly just permit me to read this judgment, my lord, with at some length, my lord. After that, my lord, as you kindly see, my lord, the para 9 first. Para 9 of the judgment, which is at page 3. Learned counsel, senior counsel appearing for the appellants argues that Section 9 of the 1996 Act envisages interim measures of protection to be granted before or during the arbitral proceedings or at any time after the making of the arbitral award, but before it is enforced in accordance with Section 36 of the 1996 Act. It is contended that the expression enforced signifies complete satisfaction of the award and not the mere filing of the execution petition. In support of his submission, my lord, those judgment paragraphs are referred. Kindly after that, this is again a discussion on the Madras High Court, etc. Then kindly see, my lord, paragraph number 11. In such view of the matter, it is argued that even if settlement agreement is, this is not relevant since the award has not yet been enforced by satisfaction, therefore Section 9 is maintainable. Now kindly see, my lord, the argument at para 19, which is the other side's argument. Para 19 at page 6, bottom of the page. Learned senior counsel for the respondents argues that as per the stand taken by the appellant, settlement is final award. However, a post-award Section 9 is not maintainable if an application for enforcement of such an award is made in accordance with Section 36 of the 1996 Act. It is contended that the expression at any time after making of the award, but before it is enforced in accordance with Section 36, employed in Section 9 of the 1996 Act is clear and unambiguous. The enforcement of an award has to be in accordance with the Code of Civil Procedure. Once a petition for enforcement of an award is filed, provisions of Order 21 of the CPC are attracted in the terms of Section 36. Therefore, application would no longer be maintainable since the award ought to be treated as enforced. Then, my lord, kindly see para 20. It is submitted that powers of executing court are wide enough to grant interim relief that a court can grant under Section 9 of the 1996 Act. Then, my lord, these judgments are referred to. Kindly now have, my lord, kindly have, my lord, para 34 now. Kindly have para 34, which is the findings. Page 11. It is at page 11, my lord. Scope of Section 9 post-award.
Post-award?
Yes, post-award. Section 9(1) of the 1996 Act commences with the following words. Then, my lord, that is set aside. That is set out. Para 35, the moot question revolves around the meaning of the expression enforced as used in the section. The respondents rely on a division bench judgment of the Madras High Court in Gopuram Enterprises, where it was held that however wide the powers conferred on a court under Section 9 of the 1996 Act may be seen to be, such powers may not extend to issuing orders for discovering the assets of an award debtor. Order 21 of the CPC that provides for execution carries the necessary provisions for such purpose, and Section 9 of the Act cannot be enlarged to incorporate the wide authority that an executing court has to aid the award holder who metamorphoses as a decree holder by the legal fiction contained in Section 36(1) of the 1996 Act to seek or obtain orders of such nature or of arrest or detention of the award debtor or sequestration of his assets and properties. It was further held that the quality of orders that can be passed under Section 9 are substantially different from the quality of orders that may be passed in course of execution. While the emphasis in Section 9 is to the subject matter of arbitration, may even charitably be seen to cover the subject matter of the award. Orders in the nature of discovering assets of the deemed judgment debtor, requiring him to file affidavit of assets and the like may not be seen within the ambit of the authority available under Section 9. Act of 1996, it was held, covers all things pertaining to arbitration and operates between the commencement of arbitral proceedings within meaning of Section 21 and conclusion. Now kindly see after that what the court says, my lord, at para 36. However, the proposition laid down in the said judgment was doubted at least by 2 single judge benches of the Madras High Court itself in such and such. Then kindly see para 37, there was a reference made to three-judge bench. Such reference was answered by three-judge bench of the Madras High Court by holding that proposition laid down in Gopuram Enterprises to be bad in law and coming to the conclusion that the word enforced under Section 9 of 1996 Act cannot be read down as enforceable and that the word enforced denotes a completed act. Thus, the phrase before it is enforced, it was held signifies until the complete satisfaction of the award. Then, my lord, para 38, there is a reference to, my lord, to the Supreme Court's decision in favor of this proposition in Hindustan Construction and also division bench decision in Dirk India Private Limited, where Bombay High Court has held that when an interim measure of protection is sought under Section 9 after an award is made, but before it is enforced, the measure of protection is intended to safeguard the fruits of the proceedings until the eventual enforcement of the award. Here again, it was held the measure of protection is a step in aid of enforcement intended to ensure that enforcement of the award results in a realizable claim and that the award is not rendered illusory by dealings that would put the subject of the award beyond the pale of enforcement. Then kindly see para 39. Contrary view was taken by learned single judge of Bombay High Court and such, observing that once the award has become enforceable, only available remedy available to the award creditor was to execute and recourse to Section 9 was not available. With utmost respect, we cannot but agree with the view taken by the division bench of the Bombay High Court in Dirk India Private Limited as well as three-judge bench of Madras High Court in BM Insulation. The reasons for so observing are discussed below. Now kindly have para 51, my lord. Para 51, detailed reasons are given, but my lord, I will not, my lord, burden your lordship with reading every paragraph. Kindly have para 51, which is at page 17. Hence, with utmost respect, the interpretation lent by the learned single judge of Bombay High Court in contrariant is contrary to scheme, as the term enforced, if construed as being enforceable, the notional date when Section 9 jurisdiction can be exercised will become totally uncertain. Another important aspect of the matter is that the remedies provided under Section 9 are not available to the court enforcing the award. As per Section 36, the provisions of the CPC governing execution of a decree shall be applicable to the enforcement of an award in the same manner as if it were a decree of the court. A mere glance at Order 21 of the CPC, which deals with execution, indicates that the executing court as such does not have specific powers to grant ad interim reliefs in aid of final execution. Now, kindly now see para 55. Thus, it would be an absurd proposition that whereas the award debtor is afforded the relief of stay under Section 36(2) in an enforcement proceeding, the award holder, despite enjoying the award in its favor and having levied execution duly, will have to wait for its fruits till the award is finally satisfied by conclusion of the execution case and remain a mute spectator till then, helplessly watching the award debtor deal with, appropriate, emaciate, and or even dissipate the subject of the award so as to render the award toothless, not worth the paper it is printed on, exclaiming the award is dead, long live the award. Now kindly see para 57. In such view of the matter, this issue is decided in favor of the appellant to the effect that the expression before it is enforced in accordance with Section 36 featuring in Section 9 has to be construed as till the award is finally satisfied by conclusion of enforcement proceedings under Section 36. Now, my lord, when we have taken steps, my lords, in this case, kindly see, my lord, this letter, my lord. I'm just to demonstrate. We have given the averments also in the section in the petition. Kindly see, my lord, when in the course of execution, my lord, and there is no dispute that this court has jurisdiction because 34 is also filed in this court. Award is passed here. Now, kindly see what the bank is writing to us. This is a letter, July 23rd letter. The bank says the aforesaid cash account is presently carrying debit outstanding of such and such, and total dues is far less than that. So, no attachable credit balance is available in the said account. So, my lord, there is we are taking our steps in execution, my lord. But, my lord, effectively, my lord, they are withdrawing money from all the accounts. And, my lord, today in a post-award situation, my lord, I am only humbly praying, kindly see, my lord, the reliefs that I have sought, my lord. There is 34, my lord. Last time I had shown the order. 34, if the in the supplementary of affidavit also, no, the order which shows that there is no stay. High Court's order. There, sir. I had placed it, my lord, last time. It is there. It is there. Kindly see, they are not prosecuting for 2 years. It is pending, my lord. No steps are being taken to even get it listed. There is no interim order. No stay at all. They have not even filed Section 36 application. Now, kindly see, my lord, the prayers that I have sought in the Section 9 petition. Kindly see para 12. These are the prayers, my lord. prayer E, my lord, if perhaps, my lord. Kindly have prayer E, my lord, at page 13. This is not a order 38 situation anyway, my lord, because there is no question of immovable property.
When was the award passed?
Yes, my lord.
Award is of which year?
Yes, my lord. Award is of 21st August 22. 23rd June 22. 23rd June 22. My lord, the award is at page, my lord, 24. And my lord,
21st August.
23rd June 22. 21st August 22 is the date of the assignment. 23rd June 22, that my lord will find at page 24 of the petition. And my lord, the relevant findings, my lord, will find at page 73 onwards, bottom of the page. 73, bottom of the page. On account of what has been discussed here and above, I hold the respondent number 1 is liable to pay an amount of 1 crore 30 lakhs 34,000 to the claimant along with interest at the rate of such and such. Further, respondent number 1 is also liable to pay an amount of 1 crore 33 lakhs 68,445 to the respondent number 2. And the respondent number 2 has subsequently, the claimant has executed an assignment in favor of the respondent number 2, and my lord, that assignment is also on record. That is 21st August 22, my lord. There is an assignment which, my lord, is at page 17. And the amount of 2 crore, my lord, has been arrived at by virtue of the interest which has been granted by the arbitrator. And my lord, the computation, my lord, will find at paragraph 12.
All respondents have been served?
All affidavit of service, my lord, reflects that. All delivered also, my lord.
All served?
Yes, my lord. Kindly see.
All served.
Yes. It says delivered, my lord. I checked it once and check it again, my lord. Akunka affidavit. Yes, my lord. Delivered. Both delivered. Yes. Delivered. And
all 4. All 3. 1, 2, 3. 3 of them.
3 have to be served. No? Yes. All 3 could be. Yes, my lord. All 3. Right. 1, 2, 3. Address delivered to address. Yes. And my lord, page 6, para 12, my lord, we have explained, my lord, how that amount of 2 crores has been arrived at. We are only claiming here, in fact, in respect of the claimant which has been assigned. I am not.
Don't even have their bank account number. No details are there.
No bank account.
Only the PAN number.
We have, my lord, only we are trying in execution, my lord, but that is
Which authority? Direction to which authority? Direction to the commissioner.
My lord, prayer E, my lord, prayer E.
Yes, to which authority? What? I can see prayer E.
My lord, this. My lord, let there be an injunction upon them, my lord. So authority, my lord, that will then.
How can there be an injunction without the bank account there? You have to give some details. Where are the details?
No, but today I'm only saying that. Yes, my lord.
Don't have the bank account details.
But the PAN number.
The PAN number will not help. Who will I give direction to? That anything against the PAN number so and so should be stated.
Only to that extent.
Can't be done.
Where income tax authority, it will be income tax.
Which income tax authority? Where is your taxpayer? Direction to which commissioner? Get some
We'll
detail.
ascertain. We'll ascertain.
Please get some details.
We'll
Where a
ascertain.
direction can be passed.
We'll ascertain.
Directions can't be passed in thin air.
We have got the now. We'll ascertain the authority and come back, Manoj.
Please
We'll do that.
ascertain the
We'll-
authority where
Yes,
a direction can be passed.
Yes, Manoj. We'll do that.
Oh, you file a supplementary affidavit.
Why? We'll
Learned counsel for the petitioner seeks and is granted 2 weeks time.
Well,
2 weeks time to
1 week. 1 week. We'll do
1
it.
week time to file a supplementary affidavit bringing on record the details of the respondent's bank or the authorities on which he seeks a direction for implementation.
I have just received, my lord, Chief
For
Commissioner, Income Tax, Kerala. But
File your affidavit.
we'll file it on
Record
affidavit.
dated 23/6/2020.
We'll file it on affidavit,
Rest after 2 weeks.
my lord.
ये लिखो affidavit of service taken on. दो affidavit है. List after 2 weeks. What is the supplementary affidavit?
That is only to place on record that Kerala we have succeeded, my lord. Initially,
Supplementary affidavit filed by the petitioner is taken on record. Affidavit of service taken on.
ठीक है.
Come
My
back
lord.
after 2 weeks.
It will come 2 weeks.
Okay.
Item 18. Item number 18.
Take down. None appears for the petitioner. Even on the earlier date, i.e. 17 June 2026, there was no appearance on behalf of the petitioner. Full stop. It seems the petitioner is not interested in proceeding the present petition. The same is dismissed for default. एक मिनट दिखाना ऑर्डर आई थिंक 2 बार भी है क्या लिखा ना did not appear on 17th as well as 13th April 2026.
No, I'm appearing for the petitioner in item number 18.
Where are you? This is the third time.
No. I'm led by Mr. Sagar Kumar Mishra in this matter. Lord, we have instructions to not place
13th
it.
April, not addressed. Dismissed as not. Learned counsel for the petitioner seeks to withdraw the present petition. Same is dismissed as withdrawn. Do you want to file somewhere else with liberty or no liberty?
No liberty, my lord.
Mr. Sujo, take it. Mr. Sujo. Item number 19.
Deeply obliged. For application, section 9 application, my lord, we have served the respondents, my lord, they have received. This is a application related arising of the loan agreement, my lord. The jurisdiction clause is as page 29, clause 11. I think Calcutta court has jurisdiction, my lord, and arbitration and seat and venue of the arbitration is also in Calcutta, my lord. Page 29, paragraph 11, clause 11.
Yes.
They have failed to pay the installment amount, my lord. We have terminated the agreement. The termination notice is at page 43, man.
Then 21.
21, my lord, we have referred, we have filed the section 9 application, my lord, for protection of interim protection of the asset, my lord, which is the subject matter of this agreement, my lord. We want the receiver over the subject assets. The asset, the description of the asset is mentioned in paragraph 6, my lord. And also in schedule, my lord, that is page 33.
Okay.
Page 33, my lord. One minute. Not page 33. The schedule of the asset is, my lord, as page 34. Clause 9, my lord. The model is automatic non-oven decutting bags.
And what is the proceeding? Proceedings have concluded.
No, proceedings is, my lord, in advanced stage, but award has not been passed. I have taken instruction, award has not been passed.
So why
But
here?
my lord, the asset, my lord, I have specific pleading here, my lord, by 17 passing and taking possession of the asset, my lord, is not. I think
I will not
it's not
entertain.
workable, my lord. I kindly kill. I have
Arbitral
made a
tribunal
pleading in.
cause- Sorry, sir.
Sir.
You want to withdraw? I'll dismiss it.
Kindly, my lord, one through the. I have pleading, my lord, paragraph 34 and 35. I have specific pleading has been made, my lord.
Doing arbitral tribunal constituted, no question.
But my lord, the arbitral.
No question.
Arbitral tribunal can pass a money award, but my lord, for taking a possession of the asset, my lord, through an arbitral tribunal, my lord, it is difficult, my lord.
Get this settled up in the division.
Paragraph 34 and 35, we have made it's difficult for us, my lord, for the petitioner to take possession through a 17 order passed by the tribunal, my lord. Interim injunction.
Can pass an order.
He can pass an order,
He
but
can pass
he
all
can.
orders.
Yes, my lord, he can pass
You
an
want to
order.
withdraw or I will dismiss it?
Kindly, my lord, adjourn for a week. I have to take instruction in that case.
No,
My
I'll
lord.
dismiss it. There's
No, my lord, because my lord, our specific case is that the asset we have only.
The petitioner has preferred the present petition under section 9 of the Arbitration and Conciliation Act, seeking appointment of a receiver to take possession of the property. It's a vehicle. What is it?
Is the asset, my lord, is some type of equipment.
Where is it mentioned?
Mentioned in page, in clause paragraph 6, I have mentioned it, my lord. At page 3, paragraph 6 of the petition, as well as page 33 of the agreement, my lord. 33.
To take possession of the automatic non-woven decutting bags machine. For the petitioner case is founded on a loan cum hypothecation agreement dated 27/1/2025, pursuant to which a sum of rupees 3,561,950 was disbursed to the respondent. Full stop. Learned counsel for the petitioner alleges default in payment of the said loan. Thereby, the petitioner terminated thereby the petitioner issued the loan recall notice dated 3rd September 2025. Full stop. The petitioner further states that he has duly invoked the arbitration clause as contained in the loan cum hypothecation agreement by issuing a valid notice under section 21 of the Arbitration and Conciliation Act dated 39/2025. Full stop. It is admitted position that the arbitral tribunal stands constituted, comma, and the proceedings are pending before the tribunal. It is reserved for pronouncement of award, and that the proceeding stands concluded and the matter is presently reserved for pronouncement of the award. Full stop. In the aforesaid factual backdrop, this court finds no justification to entertain the present petition. Full stop. The legislative scheme is explicit that once arbitral tribunal is constituted, the court ought not to exercise its jurisdiction under section 9, except in circumstances where the remedy under section 17 shown to be inefficacious. Full stop. The petitioner has failed to demonstrate any such inefficacy or any emergent circumstances warranting interference by this court. Full stop. On the contrary, the arbitral proceedings have reached their culmination and are awaiting pronouncement of the award. Full stop. Entertaining the present petition at this stage would amount to permitting a parallel recourse and would be contrary to the settled principles governing minimal judicial intervention in arbitral proceedings. Full stop. The apprehension sought to be projected by the petitioner is vague and unsupported by any cogent or contemporaneous material. Full stop. Such unsubstantiated assertions cannot form a basis of a drastic relief, including appointment of a receiver. Full stop. In the considered view of this court, the present petition is a clear attempt to bypass the jurisdiction of the arbitral tribunal and therefore is not maintainable at this stage. Full stop. Accordingly, the present petition is dismissed. The petitioner is at liberty to seek appropriate relief before the learned arbitrator in terms of section 17 of the Act.
Good.
Unnecessarily, you file these petitions. And then you want me to pass an order also. At least withdraw these petitions which are frivolous petitions.
No, but sometimes happen, my lord, it is difficult for the petitioner to go and take
Everything is concluded. Award to be published. Then you come in section 9. At least see the stage of the proceeding, Mr. Pandey. Proceedings are concluded.
Yes, my lord. That I mentioned in the petition also. Right?
That's where I'm.
Yes. But sometimes, my lord, it's difficult for petitioner also to go and comply the order.
When the award is to be pronounced, then wait. Come for a post 9.
Yes, my lord. That. Good.
On past over matter under section 11, item number 9.
According to the instructions, my lord, the opposition could not be filed, my lord. Although it was ready, it could not be filed.
Wrong submission.
But I apologize, my lord. I was not properly instructed, my lord. I apologize, my lord. I could not live up to my lord's expectations. But just, my lord, just one thing kindly gives liberty, my lord, to file just 2 days delay, my lord. My lord, kindly.
Learned counsel for the respondent seeks and is granted 1 week time to file his affidavit in opposition.
Grateful.
Reply to the same, if any, within 1 week thereafter. List after release.
I'm so grateful.
Yeah. 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 Item number 20 under section 9.
For item number 20 and 21, both, my lord, my section 9 applications in which, my lord, I'm enjoying an order of injunction. Lordship had, my lord, on the last occasion directed us to, my lord, make fresh service. We've served, my lord, for item number 20, service has been refused. And for item number 21, my lord, it's been delivered. But I was pressing, my lord, similar orders to be passed, my lord, as your lordship had passed in previous matters, my lord, for appointment of the receiver. But I'm carrying that order also, my lord. Only one small, my lord, indulgence I'm seeking. It's absolutely my mistake. But I had made a copy with the corrected, my lord, detail. But that I've, my lord, missed out. Now, if your lordship grants me, if your lordship, my lord, passes the matter or allows me to file it with my lord's officer, I'll come within, my lord, 10 minutes and file it, my lord.
Pass over.
I'm grateful.
Item number 22.
My lord, my application. My lord, I'll just indicate what is the subject matter. Main agreement between the petitioner and the respondent, which is the Hindu Unified Family and its Karta, was that I would give the respondent 270 grams of gold ornaments because the respondent was in need of financial assistance. After 2 years, he would either give me back the 270 grams of gold ornaments along with some interest, or on that date, whatever was the price of the gold ornaments, he would give back along with the interest. But that is the main case. My lord, kindly comes to my petition.
Who's on the other side? David?
Sir.
Yes, of them.
Yes.
Family dispute or what?
No, no, no. My lord, Hindu Unified Family, my lord, it is a respondent. I am a different merchant. My lord. Not within family.
Yes.
Kindly says paragraph 3. My lord, the said Shri Ranjit Sharma, since deceased, while acting as the Karta of the independent respondent HUF, approached the petitioner at his office, the address whereof is mentioned in the cost title above, seeking financial accommodation on behalf of
Who
the
is served upon? Who are the respondents here?
respondent is his wife, because he has deceased. That his wife has now become the Karta, because I can show, my lord, there is a check on which she has signed as the Karta. Well, it is annexed to in my petition. Affidavit and service.
Only the wife is there. The children are not there. You make her a party. It is Ranjit Sharma, represented by Srimati Anita Devi.
Yes, my lord. That.
So who have you served?
The letter says Messrs. Ranjit Sharma HUF, represented by Srimati Anita Devi.
Oh, the receiver is.
The receiver is Srimati. In the postal receipt, the receiver is Anita Devi, but the name item delivered, it says to the addressee.
What is your story?
But that was the main. Yeah, I had given 270 grams of gold at that point of time. We did not have cash with us. We gave 270 grams of gold to the Karta, said that.
Did you do that? Which
2023.
Where is your 21 notice?
21 and notice. There is a.
Did you issue a 21 notice?
I'll just. Mutually agreed upon arbitrator in the agreement only.
Go before the arbitrator. Why should I entertain this?
There is only one bank account and the golds.
2023, when did you issue the notice? Why should I entertain? What is the urgency in section 9? Go before the arbitrator. When did you issue the notice?
21 and notice ka kabe diya sir? 21 notice is 10/4/2026. He was supposed to return it to me in July 2025.
By this time, arbitral tribunal should have been constituted. Nothing has been done. Why should I entertain it?
Not only because of the 270 grams of gold ornaments.
No, sir. Why should I? This is the main crux of the matter. Why should I get involved in it?
There is also a check, my lord, in which they have specifically admitted of their liability. The arbitrator.
Why you have not constituted arbitral tribunal?
That
after issue of the notice. The mere formality.
Reply is check issue.
What steps have you taken after that?
21 notice have been issued on 10th April.
Then what steps have you taken?
There was no need to file a section 11 because the arbitrator has been named, a mutually agreed person, named person.
So what steps have you taken for the mutually agreed person?
তাকে লিখেছো চিঠি না না arbitrator কে লিখেছো কি বলেছে but my instruction is we have even written to the arbitrator. There is a notice.
File a supplementary affidavit. I am not interested. Learned counsel for the petitioner. Arbitration is granted liberty to file a supplementary affidavit bringing on record the steps which have been taken by the petitioner for invoking the arbitral proceedings in terms of the agreement entered between the parties. Fiction is granted 2 weeks time, 3 weeks time, just after 4 weeks. Affidavit service. Required service not available. Next.
Well, may I just pray one thing? Kindly directs us to serve upon the respondent once again. We'll do that again.
Learned counsel for the petitioner seeks and is granted liberty to effect service upon the respondent. Seeks and is granted 2 weeks time to effect service upon the respondents. Once again serve upon the respondent. List after 4 weeks. दोनों में 2 weeks 2 weeks. 3 weeks किया पहले ना 3 weeks दोनों में 3 weeks. Serve upon the respondents in 3 weeks.
না 22 শুধু 22
22টা তো 22 তো
হ্যাঁ 22
Item number 23.
Run for the petitioner.
Yes.
There's an application my lord, under section 9. Not under a my lord, previous redistribution stockist agreement. My lord, we had supplied my lord goods to them, and my lord, for which they had to pay.
Who's on the other side, Mr. Alec?
My lord, that appeared my lord on the last occasion because I had prayed my lord for a receiver to be appointed my lord in respect of those goods my lord on which payment is outstanding.
But tell me why your section 9s are being filed when you don't take any steps for constitution of the arbitral tribunal?
Lord, because section 9 my lord orders were my lord to be at that time my lord, was about to be
What steps have you
considered for appointment of arbitrator. We have not my lord, taken it.
This is the problem.
We have not taken it because my lord, I think my lord, because section 9 was pending my lord, and we wanted. In fact, my lord, we wanted my lord orders at that time my lord ex party, and my lord asked us to serve, and my lord we come back.
More reasons to have.
No, my lord, I think my lord, it's really my lord, we should have. It's really my lord waiting because my lord, the section 9 was pending my lord before court. That's the only reason, my lord. So these are my lord goods my lord which are perishable. So at that time my lord, it was called on at the first instance, and then my lord.
Where are they? We'll pass it over.
Well, we can give them notice again, my lord.
Notice. Monday.
My lord, or my lord, Wednesday, my lord, if because again, my lord, this will my lord get
Mr. Sinha, you're appearing.
none. No, my lord, my lord, friend, none.
Give a notice, come back.
So last time they took copy card. They appeared also, my lord. This is affidavit service, my lord, from the previous time, my lord.
Friday, give them a notice. Let them come. Friday. We'll have
Friday, my lord, no, my lord, Friday, my lord, no.
I'm here.
I may not be here. Thursday, my lord, if it's possible, we'll give them notice.
Thursday, then keep a Monday. Thursday
My lord,
is my execution day.
very well, my lord. Then, my lord, if it can be, my lord, little, my lord, high in the
Keep it.
list, my lord, we'll just give them notice, my lord, that it was taken up today, and then, my lord, it's been kept for tomorrow. Huh. Grateful, my lord.
No.
My lord, with my lord's permission, can we also write, my lord, we'll pray for orders, my lord, before, if they don't appear on Monday, my lord, we'll also pray for orders, my lord, on that date. Otherwise, this will really, my lord, become infructuous, my lord, in
Give
that.
them a notice.
Grateful.
Item number 24.
Lordship, kindly withdraw the matter.
Learned counsel, what jurisdiction or some other ground?
Jurisdiction.
Learned counsel for the petition seeks to withdraw the present petition. Liberty to file appropriate proceedings. In accordance. The dismissed has withdrawn with liberty as withdrawn. Liberty granted. No.
$25.
Lord, fight between two financial institutions under the Securitization Act, which has a statutory arbitration agreement.
Yes.
After the Securitization Act. You too.
So what steps, Coach, what steps have been taken?
You know, I'll tell you, Lordship, what is the issue.
Yes.
You know, there is a property. Now, it's properties, say 500 square feet of the property is mortgaged to my learned friend. 300 square feet is mortgaged to me. So there should be total 800 square feet of the property. But the property is actually only 300 square feet. So, Virat, we can't both live together. And one of our mortgages or both the mortgages will have to be hived out.
So what happened to the rest of it?
No, this is first not a particular floor of a property. So neither it's a shop room. The total area mortgage to me and my learned friend is more than the total area of the property. So, my lord, there has to be a decision, inter se banks, and both of us have done surfacing. So nobody can actually proceed with the matter because of the other's rival claim. So between me and my learned friend, there has to be a decision. And that is by arbitration under section 11 of the Arbitration and Conciliation Act. I'm sorry, of the Surface Act. Surface Act. Now there's, my lord, we've got no, my lord, allegations per se against them. They are, my lord, sailing on the same boat. So I am, my lord, Axis Finance. My learned friend is a small AU Small Finance Bank. Now, my lord, under this provision, now this has been construed by Supreme Court. Now this is 2025 9 SCC 225. Now please see paragraph 71.
So nobody has, who has the possession of the property?
We are at the possession of the property, but we are suffering an interim stay order by the learned TRT. So we are in the physical possession, but there is an stay
No,
order.
we want we want an inventory. We want an inventory in the presence of both of us, so that we go to arbitration and decide on the priority of charges, which is what section 11 is for. We don't want anything else. I don't want an injunction.
No, you have filed a section 9. So that's
Yes, so I want, my lord, a receiver to go. My lord, but if your lordship looks at paragraph 71, page 272.
This is more in terms of a civil dispute rather than, you know.
No, this is why, my lord, section 11 has been created. My lord, kindly see, my lord, the judgment once, my lord.
No, we have also passed orders appointing in one of the
arbitrator
bank cases, arbitrator
Arbitrator
in terms of
dispute
section 11, but that's a
with
different
respect
thing.
of identification of the
Of the-
property.
yes.
Yes, so that's why
That is a,
it
that exercise can't be carried out by a receiver.
local inspection, my lord, really. My lord, please see para 71.
Mortgage created in favor of both the banks are in respect of different units and in respect of different square feet. So when we have obtained our section 14 order, and then thereafter the magistrate or the executive officer appointed by the magistrate has gone there and taken possession of the property which we have found to be as the secured asset as been mortgaged with us. Now they are from then we are in the possession, in the physical possession from December 2025, but at present we are suffering an order, interim order.
I've also got a 13-4. They won't be able to sell because of that.
No, they are not. They can't.
They
are
can't.
saying that
We
there's already a
interim order by the yard.
there's already a stay. So one of the prayers the first prayer which you have to create any third party right has already been
Yes,
infructuous.
that's fine, my lord. We are not on that. Just an inventory, my lord. Lordship wants it to go to arbitrator for this. That's also,
Absolutely.
that's also, I think we can agree to an arbitrator or to agree.
Come up with an instruction,
Yes, yes.
written instruction.
Please take
from the
instructions. We'll, my lord, agree to a name.
Mr.
And
Jani,
then, my
get-
lord, we'll go before the arbitrator and claim this. I have no difficulty.
She'll get Mr. Jani, you get your instruction.
Yes, Lordship.
Yes.
Milord, for Milord, respondent number 3 and 4, Milord. But on the first day when the matter was taken up, I had indicated, Milord, that the solicitor and me both are doing pro bono, Your Lordship. The husband of this to respondent, the respondent number 3 has died, Your Lordship. The respondent number 4 is the son of respondent number 3. He's doing a very small job, Your Lordship. He's earning 16, 17,000. So, Milord, if Milord, both of us, both the respondent number 3 and 4 can be discharged. Because we have no role to play, whatever.
You are the creator.
They are the borrowers.
Well, Reena-
Lord,
She
the
said
husband
okay.
will not have committed suicide, Lord, we do not
Yes.
know anything about it. Nothing, Lord.
But you know, in terms of section what 41, what is it? 41, right? The
Yes,
legal
right.
legal heirs arbitration and conciliation act, they are co-borrowers.
They are co-borrowers. They can't get out. Husband's misdeeds.
Lord, she was
But still, you are the legal heir. Even in terms of the act, you are a party to the contract.
And here, Milord, you're a co-borrower. You've signed on the
Co-borrower.
documents.
It's
We have
not even
sympathy
legal
for
aid.
you.
You're basically a co-borrower.
not in pen and paper.
Yeah, on pen and paper.
I
Not-
have to do
Go before the arbitrator. I can't, if at all she is getting an instruction, then you also get your instruction. I'll appoint an arbitrator.
property and lordship, let them not fight.
Madam, it's not only about the property. We are talking about an arbitrator getting appointed who can verify whatever is the, the charges with him. And, whatever defense you have to take, you take over there, whether you are signatory, not a signatory, you don't know anything or whatever it is.
To bring on record this, my lord, that we do not
So
have,
why before my court? You go before the arbitrator.
we do not have the money, my lord, to pay off the arbitrator's fees and etc. Your lordship.
If you don't have the money, the arbitrator will charge one of them.
You're defending in any case.
Cover from them.
It's not your claim.
Can't be done at this stage. Not before this. You come back with the instruction, Mr. Jani.
Yes, lordship.
Grateful, Milord.
So when Monday? Monday.
Yes,
Any
Milord.
day, any day.
Not today. Monday.
Grateful.
Great.
Non 26.
Yes, Mr. Pandey.
26 to 30, my lord. In this matter, we have filed a section 9 application after termination of the agreement. But we want to know the termination was made in the month of November. We want to know the current position of this arbitration. My lord, Arjun, for a week, my lord, I have to take instruction from client. What is the status, my lord? I don't want to make wrong comments. Up to 30, my lord.
Up to 30, 26, 27, right?
So 26, 28, 29 and 30. 26, 28, 29 and 30.
Call out 27.
And non 27.
My lord, I appear for the respondent.
Lordship, in item number 26 and 27, Lordship. In appearing for the
26
irrigation-
is a different matter, sir. 26 is Ugro. We are talking about 27, sir.
No.
27 is my application.
My lord, I have a preliminary objection to the maintainability of this application.
Let him argue maintainability.
My lord, three small points, my lord.
Let's hear Mr. Sen. What is it? What application is it?
No, this is a partnership dispute application for interim measures. Partnership.
May I indicate? Very short submissions, my lord. Kindly takes the date of the application, the date it has been affirmed on is, my lord, 5th of May 2026. Your lordship will find that at page 14 of the application. Apropos this, my lord, your lordship will consider the first test, my lord, that the petition has to satisfy to maintain a section 9 is a readiness and willingness to undertake arbitration in terms of 9.3. No pleading to that effect in that application. Your lordship can take my word for it. And that, my lord, is a fatal error that goes to the very root of it. And it is not simply, sir, my lord, a case of not pleading a particular intention. There's no intention at all on record, which is why, my lord, we undertook the step to issue a 21 notice. It is my 21 notice which was issued. Give me my 21 notice. Where's the 21? Carrying a copy.
Section 11 is filed, it is pending. I don't know how this objection is coming.
For that, my lord.
Section 11 has been filed.
Yes,
Section
it is
11 has been
pending.
filed, my lord. We both filed section 11. Theirs is
Pending.
possibly.
How this objection is
So
being.
withdraw this.
My lord, not my section 9
No,
application.
it's my section 9.
So we'll appoint an arbitrator.
Yes, my lord.
But
Here's
at
the
the
section 11. We'll hear your
section 11
11.
number, it has not been listed. But
My
it
section
is-
11s have been filed.
APCOM 562 of 2020.
All the section. Give me the numbers.
APCOM 562
We'll
of
have it on
2020.
Wednesday.
Very
All these matters.
very
All these matters together on Wednesday.
Very But I would, my lord, pray for some ad interim
Mr.
release,
Sen,
but my lord, then.
I'll just provide the numbers.
You also give the number, we'll
Sure.
keep it on Wednesday.
The numbers are, my lord, if your lordship permits me, it's written in a.
That's okay.
Shown it to my learned
না
friend.
না
as
এটা
well.
কি দুটোই
Train
আছে
ticket.
দুটোই লেখা আছে
Train ticket.
I apologize, which is why I sought your lordship's leave, my lord. This should have been put in a bit different. I apologize, my lord, that I tender my application.
But I would pray for some ad interim order. It is not in
Nothing,
this.
Wednesday.
Yes, on Wednesday I shall.
But that would be the only the section 11. They can't seek an interim relief at the section 11 stage.
Nothing.
I'm grateful.
All three matters, we'll keep it on Wednesday.
Very well. I'm grateful.
Great.
তিনটে তো নট টুডে হলো 28 29 30 ডাকবো 28
For 28, 29 already.
31 31
31, my lord, I am led by Mr. Shuddhasutta Banerjee, my lord, he is on his way.
Who's on the other side?
Other side. Connected matters are Monday. Connected matters are
Yes,
kept
your
out
lordship.
day after tomorrow.
Then we'll have it day after tomorrow.
Item number 31, 32, your lordship.
Day after tomorrow. Connected matters.
Kindly, your lordship, give us a passover because we are being led by Mr. Mainak Bose. He's on his way. He'll take one more minute.
That's all right. If the connected matters are coming on day after tomorrow, we'll have it day after.
But your lordship, we are ready to move the matter today itself.
Matter.
That's a connected matter, is a new application, your lordship.
These two matters also on day after tomorrow.
Can start. Yeah. Your lordship, may I start moving?
Day after tomorrow. I'll hear all the matters day after tomorrow. What's the urgency? One day?
No, 33 33
Yes.
You'll, item 30.
Yes, 33.
Lordships, I'm seeking for a very short passover, 2 minutes passover, Your Lordship.
Then
I'm
you'll
led
have
by.
to take up on Wednesday.
No, Your Lordship, just a 2 minutes passover. I'm led by Mr. Odin Chakraborty, Your Lordship.
You start.
He's just on his way.
Start. Open the brief.
This is pending since May, my lord, so that can be.
Yes, yes.
What's the urgency today? It can't wait till day after tomorrow.
Very well. Very, very Lordship. Kindly
After
keep it
tomorrow.
honest.
no 34
My application of the section 9 led by learned AG, Advocate General here.
Yes.
My lord, I think, my lord.
The matter is fixed before the Supreme Court on 11th August.
Yes, Mr. Metro.
File our supplementary affidavit pursuant to the order dated 10th June.
May I file the supplementary affidavits, my lord?
I'll take it on record, but if the matter is fixed in the Supreme Court in 11th, then we'll have it after that.
In the meantime, my lord, if your lordship is pleased to look into, my lord, the first prayer, my lord, may I serve, my lord? Page 48 or, my lord?
We'll await the outcome of whatever happens on the 11th. Then we'll.
I can serve, my lord. He was, my lord, the
arbitrator,
conciliator,
mediator.
the mediator.
And my lord, he is holding certain funds, my lord. So, my lord, may I serve and
we'll see on the 11th.
Let it be recorded.
We'll see
They have taken.
Supplementary affidavit filed by the petitioner is taken on record. That this matter be listed on list on
Record. Have taken time.
19th.
Grateful. It is pointed out by the respondent that my lord the matter is coming up.
Learned counsel for the respondent states
That is
that
the order of the Supreme.
Even if maybe the Supreme Court will not take it up.
these are all connected to this.
Yes, absolutely.
Learned
Same
counsel for the respondent states that the SLP, special leave petition, civil number 28905/2025,
Not really
is
the same
listed on
proceeding, but
11th August 2026. Full stop. He states that the outcome of the said proceedings will have bearing on the present petition. In view of the same, he prays for an adjournment. Let this matter be listed on the 19th of August.
19th.
19th?
চলছে 25
35.
I appear for the respondent in this, Mulad.
I appear for the petitioner. This is my kindly permit me to appear on the virtual mode, my lords. That I appear for the petitioner. Beg your pardon, my lords?
Where are you?
My lords, I'm here, but there's another matter which is going. I'm so sorry, my lord. Section 9, but the arbitrators in season of the disputes, my lord, kindly grant me leave to withdraw this with liberty to file a section 17 if so advised.
All
Well, that
Learned
I'm
counsel.
possibly I'm opposing the liberty, my lord, only on a specific count. Number one, my lord, on the last occasion, they were directed to serve me a copy of the section 9. Till date, that has not come. Number two, my lord, possibly this court does not
But
have
that
the
liberty is
territorial
all.
jurisdiction.
How can you?
No, I'm opposing the liberty only.
How can you oppose the liberty? He always has the liberty to file appropriate proceedings in accordance with.
Specifically, my lord, to be mentioned by the.
Learned counsel for the petitioner seeks to withdraw the present petition with liberty to file appropriate proceedings in accordance with law. The present petition stands dismissed as withdrawn with liberty as prayed for is granted.
Grateful, much deeply appreciated.
Aye.
Grateful.
Sir, Nayak,
With my lord, kindly, my lord, item 20 and 21, lordship had passed over. Because lordship wanted us
yes,
to have,
yes.
but I'm ready with those. But if your lordship allows me, I'll file it right now.
Wait, just wait.
Very most grateful.
Grateful, my lord.
36. Item number 36, my lord, to 42 and then 56, my lord, our petitioner is the same Kobelco. My lord has passed, my lord, several orders, my lord,
Yes.
which are similar, my lord, relief I am also seeking, my lord. I'm just handing over the order. I'll show the document. My
You have made the correction with the facts in this.
no, my lord, that I
You
don't.
have done that.
No, my lord, how can I assume my lord will be pleased to grant that relief to me?
Same cases.
I would not be presumptuous to assume. my lord.
Exactly the same reliefs are being sought.
That is right, my lord.
Same parties.
Only there is a slight development, my lord, which I should inform because I was involved in that matter. One of the matters, my lord, traveled up to the division bench because there, my lord, the other side had taken a ground that because it is an assignment, they are not parties to the contract, etc. Before the division bench, my lord, they withdrew their objection, saying that this will go in section 11. In that matter, eventually division bench had initially given us receiver also. But eventually the division bench said that since you did not invoke arbitration, so in the facts of this case, we are not giving you the relief. So I'm just informing that, my lord. Although it will not have any bearing. But my lord, tomorrow, my lord, I shouldn't make the mistake of not informing the court, my lord. At a later stage, perhaps we'll try to persuade your lordship to grant relief of receiver. Not at this stage because my lord has already granted relief to similarly placed parties. So I cannot possibly ask.
Most of the matters they have.
Yes, my lord.
You're only asking for not alienating encumbering.
My lord has granted that relief, my lord, so I cannot at this stage ask for anything more.
A lot of matters I've appointed receiver also.
We have
today.
sought receiver also, my lord.
I think one of the matters which he's talking about 2021 today
My lord, we have also sought receiver, my lord.
probably is for the receiver.
Kindly see, my lord. Perhaps those orders, my lord, I couldn't lay my hand on. Receivable order nahi hai na. Kindly see prayer 2. We have also sought for receiver, my lord, in each of the matters. Page 13, the relief, sir.
I think Mr. Naik was here just now. Where is he?
My lord,
Left. Mr. Naik was here. He was appearing for Kabelpur.
for the
You
petition.
have that order? Just see, Mr. Satadaru.
Order hai.
Just see the order. I think the receiver is appointed here.
Receiver is
You
appointed.
check this order, come back Wednesday. All are connected, right? Mr. Satadaru,
My lord.
all are connected?
Yes, yes, sir.
36 to 42. Keep it on Wednesday.
ठीक है, my lord. 56 also. 56 also. 36, 56 also. Affidavit of service should we hand over to
No, keep all of
Keep
them
it.
on Wednesday.
and it will come in the daily list.
Just make the corrections.
Yes, madam, we'll do.
Basta hai.
I now 43. 43.
Nobody's here. Enough, fine. Last order. Order sheet. Nine. First time. None appears for the petition. In the interest of justice, adverse orders are deferred. Monthly PA kar do. Next week kar do. Not today kar do, see that. Just make it not.
No.
I'll just come back. Not today. Yes.
44. 44. Yes. Well, item number 44, my lord. And this is a section 9 application, my lord. I am praying for release of my vehicle. Lord, the affidavit of service has been complete. But my lord, the affidavit of service is not with me right now. Now kindly make it as not today, I will come tomorrow. Because the other side are also not here. I am grateful.
This is my section 9 application. My lord, in this case, my lord, at the very onset, my lord, I'll clarify. There are 3 respondents in this, my lord. Respondent number 2 and 3 are good service, my lord. One is refused, the other is delivered. Respondent number 1, my lord, the endorsement that's come back is no such person in the address. I'll just file the affidavit of service. If your lordship so wants, my lord, I'll reserve and come back. In the meanwhile, my lord, may I pay for
Only number 1.
only in respect of respondent number 1.
Learned counsel for the petitioner seeks and is granted liberty to serve upon respondent number 1. Seeks liberty to serve upon the respondent number 1 within a period of how much time?
2 weeks. 3 weeks, my lord.
A period of 3 weeks, list after 4 weeks. What about your 21?
20 and 21 we are ready, my lord.
21 notice.
21 notice, my lord, we haven't issued, my lord. This is coming up for the first time, my lord. This section 9 application, item number 45 is coming up for the first.
Shoot arose when?
No, but this is not with respect to the Cobelco matter, my lord. This is completely different. Similar different issue.
Affidavit service taken on record. This is in all 3 matters.
No, my lord, 46, my lord, it's delivered. 46, I'll press for an injunction, my lord. And a receiver also because it's been served. Item 46, lordship allows me to file the affidavit of service, my lord. This, my lord, the agreement is in respect, the dispute, my lord, is in respect of an agreement, which is called, my lord, sale agreement, in respect of the asset, which is, my lord, an equipment that is being given to the respondent, my lord. They were supposed to pay us in installments. May I just directly, my lord, take your lordship to the arbitration clause, my lord. That is at page number 46.
Wait.
Clause number 16.5.
Starts from page?
The agreement, my lord, starts from page number 28. The conditional sale agreement. No. No, it is C5. 433.
No, C5.
Oh, sorry. I'm sorry, my lord, I gave the wrong page now. I'm very sorry, my lord. But in this case, my lord, the agreement starts from
page 48.
Yes.
Sorry, page 28.
That's right, my lord. Lordship takes up, my lord, page number 50, capital A. That's the arbitration clause.
So what is this agreement for?
My lord, this is a conditional sale agreement in which, my lord, it's similar to, my lord, a hypothecation agreement, where the terminologies are slightly different in this case. My lord, there's an equipment which is being handed over to the what they call as a borrower himself. The payments are supposed to happen, my lord, in an installment manner. There's an arbitration clause. There's a termination that has taken place, my lord, and there are consequences of default. It's very similar to the other case that we've done, my lord. But in this case, my lord, the terminology of the agreement is different. And of course, my lord, the equipment is more or less from the same company and brand. But the petitioners are different, my lord. Lordship will kindly take up, my lord, 50 capital A once, my lord. (16.4) and 16.5.
Page?
50 capital A, my lord. The pagination is, my lord, right after page number 50. Lordship will see, my lord, there's one illegible copy. Right after that is a typed copy. Yes. Lordship will kindly, my lord, take a look at, my lord, clause 16.4 and 16.5. 16.4, I'll just read for my lord's convenience, my lord. This agreement shall be governed and construed in accordance with the laws of India. The courts in Kolkata shall have exclusive jurisdiction over all matters arising pursuant to this agreement. Now, 16.5, my lord, arbitration. 16.5.1, in case of any dispute, this is with respect to, my lord, amicable resolution. Now, Lordship directly, my lord, takes up 16.5.2. In the event no amicable resolution or settlement is reached within a period of 30 days, such dispute shall be adjudicated by online and or physical arbitration in accordance with the provisions of the Arbitration Conciliation Act 1996 and rules framed thereunder, and any amendment, modification, statutory enactment thereto from time to time, and shall be referred to the arbitrator of a sole arbitrator appointed by the company upon intimation to all the parties. This part of the clause is obviously not gone today.
These,
Now, my
these
lord,
are also those excavators.
yes, the equipments are the same. Well, I'll just quickly indicate, my lord, the asset ones. Lordship will kindly take up, my lord, 52. Page number 52, capital A, my lord. Lordship is at 52, capital A, my lord. Serial number 1, the brief description and equipment. The first payment started from 2025, my lord, January. And the last installment is to be received, my lord, 20th of June, 2028. That's serial number 11 of that chart. Now, one other clause, my lord, I'll just quickly indicate. Your Lordship kindly takes up page number 45, capital A once.
Yes.
Clause 11.2. 11.2.1, on occurrence of any of the events of default, the seller shall be entitled without prejudice to any other right or remedy which the seller may have under this agreement or otherwise under applicable laws, and notwithstanding any subsequent acceptance of the total installment or any other charges payable under this agreement, Lordship will kindly look at B, to terminate this agreement in the manner set out below. The seller shall give a written notice default to the purchaser. Now the details are there. Now Lordship will kindly take up page number 48A. This is the consequences of termination. I'll come to the termination letter last, my lord. 48, capital A. Specifically, my lord, 14.2.2. In the event of termination of this agreement, by reason specified in 14.1.2, the purchaser shall make payment of all dues and outstanding amount to the seller as on the date of termination of this agreement, as may be payable under this agreement, exercise either of the following options. 2 is, my lord, surrender. Now, serial number 3, my lord, C, my lord. If the purchaser fails to exercise any of the aforementioned options, the seller shall have the right at their discretion and without notice to the purchaser to enter any premises where the equipment is or is believed to be, dismantle and repossess the same, along with whatever attachment, data, contents or other information embedded with the equipment, without being answerable for any cost, loss, damage to the purchaser or to any other person. Upon repossession, the seller may dispose of or do any act in furtherance of the same, without being accountable to the purchaser for any profits whatsoever. The purchaser undertakes to reimburse all losses to the seller in such event. Now, Lordship will look at my termination, my lord.
Page.
Yes. Lordship will look at page number 91. Page number 91, it starts, my lord, the letter is dated 24th of March 2026. My lord, the relevant clause, my lord, the relevant paragraph, my lord, is paragraphs, my lord, 4, 5, and 6. The total amount due is, my lord, in paragraph number 7. The chart is there. But in the light of this, my lord, I'm praying for prayer A and B. At page number 20 of the application, my lord. I'm sorry, my lord, starts at page number 19, bottom.
Yeah. Take down the petitioner. The petitioner preferred the present application under section 9 of the Conciliation Act, seeking injunction restraining the respondent or their agent from alienating, dealing, or disposing of the assets under the agreement dated 9/1/2020, as well as seeking appointment of a receiver to take physical possession of the said asset. So it is the case of the petitioner that the petitioner had entered into a conditional sale agreement dated 9 January 2025 with the respondent number 1 for purchase of a equipment the respondent number 2 and 3 were the guarantors. Full stop. Pursuant to the said understanding, a conditional sale agreement dated 9 January 2025 was executed between the petitioner and the respondents, wherein the petitioner had advanced a loan of rupees 86154,750 in the form of asset finance for purchase of one Cobelco SK520 XTLC hydraulic excavator YS14505-311. Why there are so many numbers here?
Well, the multiple, my lord, devices, equipment.
All were purchased from this loan?
Yes, yes, from under the same agreement.
Yeah, page 92. Cobelco so and so, comma, then ये करके यहाँ से आए. ठीक है. Page 42. Part portion. Learned counsel for the petitioner states that in terms of the said agreement, the loans were to be repaid in 42 installments. Full stop. It is the case of the petitioner that the respondents defaulted in repayment of the monthly installment, and thus compelling the petitioner to issue the loan recall notice dated 24th March 2020. Learned counsel for the petitioner submits that a total balance of 864,884,83 is due and payable to the petitioner in terms of the said conditional sale agreement dated 9th January 2025. Full stop.
Amount of the in the termination notice.
It is the case of the petitioner that if the respondents are not restrained from selling, alienating, or creating any third party rights in favor of a third party, the petitioner will suffer irreparable loss. Full stop. This court is prima facie convinced that a loan agreement, a conditional purchase agreement was entered into between the petitioner and the respondents dated 9th January 2025. In terms of the said agreement, an amount was disbursed in favor of the respondents. Full stop. It is from the record that's evident that the respondents had defaulted in repayment of the said loan agreement, making it prima facie a case in favor of the petitioner for grant of an ad interim.
90 days. The first order.
The balance of convenience lies in favor of the petitioner, that since third party rights are created, the petitioner will suffer irreparable loss. In view of the same, this court restrains the respondents from alienating, creating, or creating any third party interest in terms of the assets as mentioned. Wo jo assets hai na, jo page 92 pe mentioned. Further, this court appoints a receiver to take possession of the said property. Will appoint somebody, receiver so and so is appointed as the receiver to take possession of the property. The receiver shall file his report on the next date, list after 4 weeks.
My lord.
Or 6 weeks, list after 6. Affidavit of service taken.
47 or 40.
Yes, next.
The item number 47 and 48 are similar to item number 45, in which the first respondent has not been, the endorsement is no such person. And
Same order as 45.
may I just file the affidavits?
47, 48, 130 order. 47, 48.
With your lordship's kind leave, my lord, may I take the liberty
Yes,
for
item
20 and 21?
22.
First one matter, item number 20.
20, my lord, this is my affidavit of service. My lord, this is the order, my lord. We made the necessary changes also in that, my lord. In fact, this was on the non-commercial division, so we've written commercial division also. That also we.
The first one APCOM is 20, right? 270 is 20, item 20.
270 is item number 20, my lord. Item 20. KV Anand and another was.
ये order. And 21?
21, my lord, is
Yeah.
APCOM number 274. So this is the affidavit of service. Means,
Incorrect. Okay. It's 21.
Yes,
Thank you.
I'm grateful. Anika, see what happened. What? We're all right. After 6. Yes. You see what happened? I know 49.
This is my application. But may I file the affidavit of service? But I'll tell your lordship before my lord anything, my lord, this is a post-award section 9. Now, my lords, I'll tell your lordship, here the award has happened through that online dispute resolution mechanism, and I know your lordship has expressed a certain view in that. So far as my lord, now my lord, what I am seeking is, my lord, a post-award section 9. My lord, I am taking, my lord, that, my lord, if your lordship is not even considering the award also, my lord, in that case also, my lord, I am saying that I am entitled to an order under section 9. But for that, my lord, now this issue, my lord, perhaps, my lord, came up, my lord, before different high courts. And, my lord, now it has been conclusively decided by the Honorable Supreme Court, my lord, in April 2026.
But even if the award is a nullity?
My lord, yes, even if it's a non-enforceable, yes, even if it's, because that was the precise issue. May I just show your lordship that an unsuccessful party also, my lord, can claim an award under section 9, post-award section 9. My lord, kindly takes this judgment, my lord, because, my lord, different high courts had taken different views. There was a conflict between Delhi, Bombay, and, my lord, the Karnataka and Telangana view. Now, if your lordship directly takes, my lord, paragraph 2, my lord, that's the substantial question of law. The substantial, my lord, if I may place, my lord, the substantial question of law that arises for consideration in the present batch of appeals is whether a petition under section 9 of the Arbitration and Conciliation Act 1996 at the post-award stage by a party that has lost in the arbitration proceeding and has no enforceable award. No enforceable award in its favor is maintainable in law.
Sir, you can't read it like that. No enforceable award is in terms of the person who has lost it. No enforceable award in terms of this unilateral appointment is entirely different.
But I've understood what is
the way you are reading it, you have divided the two. All right. So you are saying somebody who has lost it, but the award is unenforceable. No, sorry, that is not how it is written here.
Now, my lord, if I may just show your lordship, my lord, from the other paragraphs, my lord, if I may, my lord, I may just try and persuade your lordship with
award is a nullity.
Yes, award is a nullity, my lord.
And it can be enforced.
No, my lord, I am not enforcing an award out here. My lord, all that I am seeking is in section 9.
Protection and section 9 for an award which is a nullity.
Yes, my lord.
Please show me.
For the subject matter, my lord. Yes, my lord. If I may just show your lordship the relevant, my lord, I can try, my lord, and persuade.
Show it. I'll be happy.
I'll try your lordship to. My endeavor is to persuade your lordship.
I will be enlightened.
If I may show this judgment, my lord, this judgment actually takes.
Don't read this paragraph.
No,
No,
my lord, that was the issue. Now, my lord, I'll show the discussion.
Different. Here the issue is different.
My lord, the unsuccessful
part.
part.
Break the two, which is not.
My lord, that issue.
This has to be read by a party that has lost in the arbitral proceeding.
And your lordship.
And
My lord, I bow down to your lordship on
that.
And
no enforceable award in its favor.
Right.
What does it mean?
That there is no award in my favor.
For a party who has lost.
Who has lost in the arbitration. My lord, there is no award. Correct. Now, my lords, now. Yes. No, my lords. I'll just now, my lords, if I may just take your lordship, all the arguments happen, and my lords kindly come straight away to paragraph 28.
We can see the arguments also.
Yes, my lord. If your lordship wants, my lord, I have no problem, my lord.
I want to be enlightened. You know?
Very well, my lord. Then let me show you, my lord, in details this judgment.
Then we'll have it after that.
Yes, sir. Very well.
We'll read it
very well.
In detail.
Yes, sir. And that portion, my lord, what has fallen from your lordship, that you go apply de novo, that aspect is also taken care of out here. I'll try, my lord. My lord, I'll try to persuade you, lord.
We'll see.
Very,
Every proposition has to be tested.
very well.
Can't be thrown outright.
No, no, no. But My lord, since my lord, we had the recess, my lord, let me, my lord, approach this in a slightly different manner. But section 9, my lord, if we see, section 9 is in aid of the arbitration agreement.
So let's read section 9 first.
Yes, my lord. But kindly take section 9. If I may please. A party may before or during the arbitral proceedings. Let's should I hand it over?
No, yeah.
Oh, it's there. A party may before or during arbitral proceedings or any time after the making of the arbitral award, but before it is enforced in accordance with section 36, apply to a court. For appointment of a guardian for a minor or a person, my lord, this part one I am, my lord, excluding for the timing, my lord, kindly come. 2. For an interim measure of protection in respect of any of the following matters, namely, now my lord, kindly takes A, the preservation, interim custody, or sale of any goods which are the subject matter of the arbitration agreement. So, my lord, that is where, my lord, I am, my lord, submitting to your lordship that it is in aid of the arbitration agreement. My lord, it may so happen that the mandate may be a nullity, but my arbitration agreement is not a nullity, and the arbitration agreement remains. So, my lord, in that perspective, my lord, if your lordship sees, my lord, I do have a right, my lord, even in such a case, my lord, where, my lord, my award may be declared as non-est for whatever your lordship has said fallen, my lord, that in fact is there in this judgment. I'll come to that, which says that, my lord, post that, even the post period, my lord, that if I have to start de novo also, my lord, in that case also, my lord, I have a right, my lord, under this section 9. My lord, that is on the maintainability aspect. My lord, and that is what I'm trying to, my lord, persuade your lordship that, my lord, I have a right, my lord, under section 9, even, my lord, if my award is declared to be a nullity, because it is aid of the arbitration agreement. Because, my lord, the language of section 9, my lord, it is in aid of the arbitration agreement. My mandate is a nullity, my lord. I'm accepting, my lord, for the timing that my mandate is a nullity. But my arbitration agreement still remains. And that is why your lordship, my lord, in the other matters, my lord, whatever, my lord, with regard to this online dispute resolution, your lordship has said, you may start de novo if you want to. That is because the arbitration agreement still subsists. Now, my lord, kindly takes this judgment of the Supreme Court in that perspective.
So I have a query.
Yes, my lord.
Let us assume that you have a right.
Yes, sir.
We are not on the issue of maintainability of the section. You have come here post award.
Yes, my lord.
What is the method of executing an award?
Method of
execution of the award?
Exclusion.
Execution.
Execution. My lord, by filing, my lord, an execution application.
36.
Yes, my lord.
In this scenario, why a 9?
My lord, till the time it is filed.
So what is the period?
My lord, the
When
period,
have you come?
my lord, if your lordship,
What is the date of the award?
my lord, date of the award is there, my lord, but the service, my lord, whether it has happened or not, we are not, my lord, clear on that.
That can't be a ground.
My lord,
If the award has been passed on next date,
yes, my lord.
you have a period when, a 34 is filed. 30 days.
Yes, my lord.
So if you have not exhausted it, or the other side has not exhausted it, why should I interfere in?
My lord, in that case only, my lord, I am saying, my lord, today, my lord, my right, so far as, my lord, the other side.
I'm taking your argument.
No, my lord, that is what I want to show, my lord.
Still.
My lord, I want to show.
36.
My lord, that is what I want to show
This
you.
is not.
My lord, that is
You know why
exactly.
you're not going in 36?
My lord, I am telling you
why you're not going.
because, my lord, it will be declared, my lord,
Exactly.
and honest. My lord, in that case also I am saying, my lord, I am
That's why you have
admitting
filed.
that. I am admitting
You
that,
have
my lord.
filed this 9 because you know the view of the court. And in 36, I'll throw you out.
My lord, I am not joining issue on that at all. My lord, I am saying, my lord, irrespective of the fact, my lord, that also has been dealt with out here.
You all know now how to hold the ear.
My lord, no.
So when you can't
Not
hold
at
it
all.
like
My lord,
this, you hold it
my
like this.
my attempt is only to.
What you're trying to do.
My lord, my attempt is only to pursue your lordship. I will show, my lord, from this judgment itself.
I know why you're pursuing, and I'll dismiss it. Don't worry.
No, my lord.
with reasons I'll discuss
Well,
it, but I'm just saying.
I have understood what your lordship is saying. Well, I am telling your lordship, I'm not joining issue on that aspect. Well, in this judgment itself, it says even if my 36 is barred.
That's because you know that if you file a 36, I'm going to set aside.
Yes,
your award. So you decided a novel idea to file a 9.
Well, if
Let
the law,
me secure.
well, if the law provides
I'll
me,
tell
well,
you how it doesn't provide you. Efficacious remedy is 36, not this. And I'll distinguish it to that extent where an award has been passed, time frame has been given for a 34. You prefer not to file a 34. You file a 9 to avoid execution of the award, which will be an honest, which I'll hold in 36 that you have filed your 9.
well, may I, my lords, just tell your lordship this much, that so far as 34 is concerned, my lord, I have got an award in my favor. So filing of the 34 is not in my hand. I can, my lord, only file an execution application.
File an execution.
Well, that's what I'm saying.
Absolutely file an execution.
Well, it's the only thing, my lord, I have not yet filed that execution.
File.
My lord, in that case, in
File
that
an
scenario,
execution.
my lord, I am just trying to tell you, persuade your lordship that in a scenario where, my lords, I have not filed, my lord, and
you have a better case.
My lords,
Why you have a better case? Because you are not supposed to challenge the 34, right? You are not supposed to go by the timeline. They have failed. They have a great case in 36, isn't it?
My lord, my lord, on that issue, my lord, I'm not joining issue at all. My lord, I have bowed down to your lordship with whatever you're saying on that. But my lord, I am just saying, my lord, prior to filing of that 36 application, my lord, my right under section 9 remains, and my lord, I can exercise it in law.
I'm not denying. Am I denying it?
My lord, may I just show your lordship that?
Yes, yes.
My lord, kindly takes the judgment.
I'm just showing you why you have filed this.
My lord, exactly what your lordship.
Exactly why.
Yes, yes, my lord, I am telling your lordship that. I am, my lord, not saying that.
Give all those observations.
My lord, your lordship may.
And I'll dismiss with a very heavy cost in
Well,
this because you have come here trying to play around with the court where you know that you are not going to get anything in 36 in the execution, so you have filed this.
Well, if I may just.
So I will distinguish this. I will give my finding, but I assure you that I'm going to dismiss it with cost.
Well, I may just make an attempt to persuade your lordship.
I'm not denying that you don't have a case.
I am not saying, my lord, first thing, my lord, I told your lordship, my lord, that it was an online dispute resolution, and I know your lordship's view. My lord, taking all that, my lord, I don't want to, my lord, suppress any facts from your lordship. My lord, it's an attempt.
I'm not saying you're suppressing.
My lord, it's an attempt made to your lordship's, my lord.
Section 9 is maintainable. But in which scenario?
My lord, in this scenario, if I may show, my lord, my attempt is to, my lord, persuade your lordship on this. If I may, my lord, with this, my lord, with this judgment. Kindly have a look at it.
You know, the financial companies, when they act smart, you know, it just kind of irks you.
Well, I understand, my lord, what has fallen from your lordship, but my lord, something has happened.
Something has happened. See, a lawyer is supposed to do his job. So I have, you know, nothing against.
Well, something has happened.
Your point of law which you are trying, but
my only attempt is, my lord.
The way they are trying to do.
I understand, my lord, what is falling from your lordship. I understand, but my lord, my attempt, my lord, is to, my lord, pursue
heavy financial cost.
My lord, let me, my lord, kindly show your lordship this.
Heavy financial cost. Not to you, but to your.
My lord, your lordship is, my lord. Lord, I am getting intimidated because
I know exactly what they're doing.
Lord, if I may just show your lordship this. Lord, kindly have a look at it. My lord, because what your lordship has said, my lord, in one paragraph, my lord, that aspect has been covered. That's why I'm saying.
Why don't you do one thing? You just hold on to all this for a couple of months.
No, my lord, I don't want to, my lord. My lord, I think, my lord, I may make an endeavor, my lord, as a, my lord, as a counsel, my lord, to persuade your lordship on that.
You're a good counsel. I have no doubt about
it. No, my lord, I may make an attempt. Kindly permits me to just, my lord, show your lordship, my lord, what has been held. Yes. Because, my lord, all these situations actually has been contemplated out here in this judgment. Had it not been, my lord, first thing, my lord, I looked for, my lord, is, my lord, whether there something is there or not, my lord, and my lord, came across this, my lord, which was there, my lord, passed in April. Because this was an issue, my lord, which was troubling, my lord, a lot of courts. Even this issue, my lord, perhaps has been touched on. Now, my lord, if your lordship takes, my lord, I have shown your lordship the question of law.
Convinced, then you will not. You will withdraw this, and you take your remedies in law. Don't waste my time.
First, let me try and persuade
But
your
you make me write a judgment where I have to distinguish all this, and then I'm going to impose cost.
May I just persuade your lordship, my lord? Kindly, my lord, for a minute, my lord, kindly keeps us, my lord, kindly takes, my lord, what is, my lord, appearing in this judgment.
Here comes Mr. Sinha, the brainchild of all this.
Now, my lord, kindly comes, my lord. My lord, if your lordship wants to see, my lord, arguments, my lord, which was made, my lord, I was, my lord, just to save time, my lord, I was just taking your lordship because the reasonings are, my lord, quite, my lord, elaborate.
Whatever you want to read, whatever paragraph.
My lord, I just want to show your lordships. Kindly then takes from paragraph 28 onwards. My
I
lord,
wish
with
you
the,
were here 5 minutes before.
I was following, but I have followed every word that you have said. But I was there online. I have followed.
Yes.
my lord, kindly takes reasoning, meaning of the term a party cannot be contextually modulated or varied depending upon the outcome of the arbitral proceedings. It is a settled principle of statutory interpretation that where the words of a statute are clear, plain, and unambiguous, the court is bound to construe them in their natural, ordinary, and grammatical sense, giving effect to the legislative intent without resort to any interpretive embellishment. In R versus Oaks, 1959 to Queen's Bench 350, Chief Justice Lord Parker said, where the literal reading of a statute produces an intelligible result, there is no ground for reading in the words of changing words according to what may be supposed intention of Parliament. Now, let's kindly take para 29. Section 9 of the Act commences with the expression of party, which by virtue of Section 2H of the Act is defined as a party to an arbitration agreement. Neither Section 2H nor Section 9 of the Act draws any distinction between a successful and an unsuccessful party in arbitration proceedings. Then if your lordship takes para 30, the object of incorporating definitions within a statute is to assign a precise and particular meaning to term in the context of that enactment. It is only in situations where a term remains undefined in the statute that the court assumes the duty of ascertaining and delineating its meaning through principles and interpretation. Then, moreover, to assign a different meaning to the same expression, namely a party in the context of interim measures sought after the arbitral award has been rendered, but prior to its enforcement, would result in an anomalous situation. Such an approach would imply that before the award is delivered, the term a party encompasses all the parties to the arbitration agreement, whereas after the award, the same expression would acquire a narrower connotation, referring only to the successful party in the arbitration agreement. Then, if your lordship sees, this court is of the view that the statutory framework does not prescribe any qualification that would confine the availability of post-award relief under Section 9 solely to award holders. Now, let's kindly see thereafter further this court is of the opinion that acceptance of the views expressed in Duck India, Nusli Switzerland Limited, Padma Mahadev and A. Chidambaram would deprive the unsuccessful party of a right expressly conferred by the Act. Consequently, this court holds that the meaning of the expression of party cannot be contextually modulated or varied depending upon the outcome of the arbitral proceedings. Such modulation would amount to judicial amendment of the statute, which lies beyond the province of the court. Then object of Section 9 is to ensure that parties have right to approach the court for interim measures till the judicial process has reached its culmination. Then, additionally, Section 9 of the Act expressly permits any party to an arbitration agreement to approach the court for interim measures at 3 distinct stages. Prior to the commencement of arbitration, during the pendency of arbitral proceedings, after the award has been rendered, but before it is enforced in accordance with section 36 of the Act. So, 3 stages clearly, distinctly spelled out. 35. On its plain language, the provision does not distinguish between a successful or unsuccessful party. It does not expressly bar a party whose claims have been rejected by the arbitral tribunal from seeking interim reliefs after the award is rendered. A literal interpretation of Section 9 of the Act would indicate that the right to seek interim relief is available to any party to the arbitration agreement before or during arbitral proceedings or at any time after the award is delivered, but before it is enforced in accordance with Section 36 of the Act. Then, if your Lordship sees, indeed, while construing Section 9 of the Act, Sundaram Finance is quoted, that portion, I am just for the timing, and if your Lordship directly comes to from 39 onwards thereafter, from the foregoing, it is evident that the Indian Parliament has consciously conferred an additional right upon parties to seek measures after the arbitral award has been rendered, but prior to its enforcement. This departure from Article 9 of the ancestral model law by introducing a post-award stage during which interim relief may be sought demonstrates that the legislature deliberately expanded the scope of Section 9 of the Act. But here, my lord, just pausing here for a moment, 1940, my lord, I'll show your lordship Section 18. Apropos this, my lord, what it said about this. And my lord, that also has been considered in this. But kindly now, my lord, see, significantly while doing so, it did not impose any restriction on the category of parties entitled to seek such relief. Then, my lord, the interpretation adopted in Duck India appears inconsistent with the statutory scheme. By restricting the availability of post-award interim relief to a successful party, the judgment introduces a limitation unsupported by the language of Section 9 of the Act. If the legislature was, while consciously deviating from the ancestral model law, intended to impose such a restriction, it would have done so expressly. Consequently, the court is of the considered view that the object and purpose of Section 9 of the Act is to ensure that the parties retain the right to approach the court for interim measures until the judicial process has reached its culmination. Now, its next heading is also important. Section 34 as well as Section 32, 36.2 and Section 9 operate in distinct spheres. The mere availability, let kindly seize this, mere availability of recourse under Section 34 or a stay under Section 36 of the Act cannot operate as a bar to seeking protection under Section 9. Section 34 as well as Section 36 provides remedies against an award or a stay thereof, whereas Section 9 ensures protection of the subject matter or the amount in dispute. An unsuccessful party cannot secure protection of its claim under Section 34 or 36. My lord, in this case, if my award is rendered non-est, my lord, I will be, my lord, in one way or the other, the unsuccessful party. To deny interim relief under Section 9 would leave such a party remediless. In fact, if the court declines to entertain an application of a losing party for interim relief, there would be no forum available for protection of the subject matter, even where the award under challenge is stayed and potentially liable to be set aside. Moreover, the ultimate outcome may alter the rights of parties, and therefore distinction between a winning and a losing party cannot govern access to the remedy under Section 9 of the Act. Then your lordship sees fundamental assumptions of Dirk, that portion. Let's now kindly cease from 45. In fact, my lord, from 44. The fundamental premise on which Dirk India, Nestle Switzerland Limited, Padma Mahadev and A. Chidambaram held that an unsuccessful party post-award is disentitled to seek interim relief is that under section 34 of the Act, the court may either dismiss the objection to the arbitral award or set it aside. Therefore, the interim measure of protection is intended to safeguard the fruit of the proceeding until the eventual enforcement of the award. 45. The assumption is untenable in law, for it now stands conclusively settled by the Constitution Bench judgment in Gayatri Balaswamy Supra that courts exercising jurisdiction under section 34 and 37 of the Act possesses the power to modify an arbitral award where the award is severable by exercising, it should be, by excising the invalid portion from the valid portion and by correcting clerical, computational or typographical errors, or by modifying post-award interest in appropriate circumstances. It has also been held that this court, in exercise of its power under Article 142 of the Constitution, has the authority to amend the award. Now, 46 is extremely important. Besides, the court may quash an award, thereby leaving the parties free to recommence arbitration de novo, should they so choose. My lord, we are contemplating a situation like that, where, my lord, your lordship's view is, my lord, you may start de novo, but this mandate is a nullity because it's an unilateral appointment. It is also pertinent to note that section 43(4) of the Act stipulates that the period between the commencement of the arbitration and date of court's order shall be excluded for computation of period of limitation for the initiation of proceedings, including arbitration, in respect of the dispute submitted. Additionally, the expression subject matter of arbitration and amount in dispute used in section 912 of the Act are broader in scope, width, and amplitude than the phrase fruits of arbitration, where the legislature has expressly provided that measures under section 9 of the Act may secure the subject matter of arbitration or the amount in dispute. The court in Dirk India, Nestle Switzerland Limited, Padma Mahadev and A. Chidambaram could not have restricted its ambit to securing an enforceable claim of the unsuccessful party. Such a restrictive interpretation is impermissible when the language of the provision is plain and categorical. Now, my lord, kindly takes 48. It is noteworthy that under section 18 of the Arbitration Act 1940, my lord, the previous view, the grant of interim measures was expressly confined to the successful party and directed solely in ensuring enforcement of the award. So, my lord, previously it was only for enforcing of the award that a post, my lord, application would have been made for interim protection in the form of section 18. In contrast, under the Act, the legislature in its wisdom has imposed no such restriction or qualification upon the court under section 9 of the Act. Consequently, the legislative intent is manifest. Now, let's just pausing here for a moment. If I may just hand over to your lordship, section 18 of the 1940 Act. Kindly has a look at it. Yes. But section 18, my lord, of the 1940 Act, my lord, it was for enforcement of the arbitral award and interim relief after award. This was the law under the 1940 Act. And under the 96 Act, my lord, that's the distinction, my lord, which has been, my lord, noticed by the Honorable Supreme Court in para 48. In contrast, under the Act, the legislature in its wisdom has imposed no such restriction or qualification upon the court under section 9 of the Act. Consequently, the legislative intent is manifest. Now, even if purposive interpretation is applied,
the expression a party means party to the arbitration agreement. Even applying the test of purposive interpretation, a party must mean any party to the arbitration agreement. This court can envisage situations where a party that has lost, kindly note this, that has lost in arbitration may nonetheless require interim protection. For instance, where an arbitral award, kindly notes this, for instance, where an arbitral award has been rendered without proper notice to a party, or where a party
Yes.
or where a party is able to prima facie demonstrate the award has been induced or tainted by fraud or corruption. That is also taken into consideration. In such situations, the court may not only stay the award, but also grant interim measures under Section 9 of the Act to balance the equities. Similarly, in certain cases, an unsuccessful party may have obtained interim protection under the arbitral proceedings, such as an order restraining invocation of a bank guarantee. Upon the rendering of the arbitral award, such interim protection ordinarily stands vacated. However, the unsuccessful party may challenge the award under Section 34 of the Act and obtain a stay of the enforcement of the arbitral award under Section 36(3) of the Act. In such circumstances, immediate removal of interim protection, for example, in relation to a bank guarantee may result in irreversible prejudice to the unsuccessful party whose challenge to the arbitral award is pending adjudication. It's paragraph 50 thereafter. Further, the courts are not disabled from granting non-prejudicial interim relief in favor of an unsuccessful party in arbitral proceedings, particularly where such relief does not affect the enforceability of the award, but merely preserves ancillary rights pending adjudication under Section 34 of the Act, as was sought in such and such. Then another interesting conundrum may be where a party is partially successful in as much as part of its claim are allowed, but as a consequence of a higher amount of counterclaim being allowed, it is branded as an unsuccessful party in accordance with DIRC India and is not in a position to prevent the other party from selling its assets after the award has been rendered. It is possible that in Section 34 proceedings, the arbitral award may be modified to the extent of that the counterclaim is set aside and severed from the award. However, without interim reliefs, assets may dissipate, rendering final success illusory. Then let's 52. Consequently, in rare and it may be necessary to permit the unsuccessful party to invoke Section 9. It continues, so the point out here is that till the time I file, it's not a bar to filing a Section 9. And though I have not filed a 36, I have the right, and 36 cannot stand in the way of me filing a Section 9. If I can on merits, because subsequently, if your lordship takes para 59 onwards, what do I have to satisfy? Para 59 says, what is the threshold for interim relief higher for unsuccessful parties? I am taking here that this award will assuming that may be set aside, will be declared, the mandate will be declared a nullity. It is a possibility. And it will happen, eventually. But that, perhaps, subject to what your lordship holds, that Section 9 right perhaps will not be taken away. And 60 also says so, and therefore,
not applicable. Absolutely not applicable. You want me to give a finding on this? I'll dismiss with a cost because, and I'll record everything that why you have filed this. I'll make it very clear. No, I'll distinguish it. I have no problem. I can see it. If you want me to dictate an order, I'll dictate right now. I'll deal with your judgment. But this is literally playing a fraud. Nothing.
I am just trying to exercise my right under Section 9.
I will deal with
that. Is No, no, my lord, what I want to show to your lordship is that only, my lord. My lord, what will happen, my lord? My lord, let's assume for a moment, my lord, if my lord, my award, my lord, if my award, my lord, is perhaps, my lord, set aside. My lord, it gets set aside. Then, my lords, your lordship has said in the
Section 9 is maintainable. I'll hold it. It is maintainable as an interim relief. That is the idea of the legislature, is that it's an interim protection which is granted to you, not for an award which is passed on 10th November 2025, wherein you have failed to file your execution proceedings and you have come in Section 9, knowing very well that it's a unilateral award which is to be set aside. This is not a proceeding filed by an unsuccessful party. And the definition of party is not attracted to you the way that you are reading it. It is entirely in the facts of that particular case where it is entirely different when it comes to this matter. I'm really sorry. It doesn't attract the facts of your case at all. You have an efficacious remedy available in law for you under Section 36. Go and file your execution proceedings.
I
don't want to file your execution proceedings because your award is a nullity in 36. It will be set aside.
Then my
That's the only reason, and I'll record that. Why you're not filing it? Why you have filed a Section 9? What is the idea behind this? How you are trying to play a fraud upon the court and impose a cost of 2 lakh rupees and dismiss this? That's exactly what I'm going to do. You're a financial institution.
Well, my only endeavor, my lord,
yes,
before your lordship is to only
take it, challenge it,
my lord, only to show, my lord,
test it.
my lord,
One more
my
judgment.
lord, if say, my lord, a award, my lord, is set aside, my lord, for mandate.
I am not getting it.
My lord, if the mandate is a nullity, that is what your lordship is on.
I know exactly why you have filed this.
My lord, that is what I'm saying, my lord. If today,
that's
my
why
lord,
I'll give a finding to it. That an award of November, 10th of November 2025, waits till August of 2026, whereas there's no, you have a, what is first basic principle of Section 9? Interim measure. What do you mean by interim measure?
Well, protecting the subject matter.
Expeditious interim measure.
Right, my lord.
Why did the legislature carve out a distinction from the unsitral? To give an expeditious interim measure. Why? Because suppose you have a award and it gets disposed of within that period of 34, because there's a period that liberty is there, right, to give you that protection. Not for your enforcement of award by a Section 9 after 1 year.
Well, only thing.
After more than a year. Section 9.
Well, all that I'm saying is, well, so far.
Mr. Gochu, please, you tell me, Mr. Sinha, you want to test it in the division bench and Supreme Court? Most welcome. But I think this is a bad case to test. You have other cases to test. You should have done that. You want order in this? I'll do it. Find a better case to test.
Very well. But he's saying, my lord, if he can come back, my lord, and take, my lord, instructions.
Please come back, because I'm telling you, it's not about any of the lawyers. I mean, I like impunity. I'm actually very happy to hear this side of the argument also. It gives me great pleasure to see how you come up with,
Well, it's an attempt, my lord. I can only try and persuade you.
I totally appreciate your attempt. But again, to the extent that it should not look like you're playing a fraud.
No, my lord,
it's not
know.
you.
I understand what your lordship is saying. All that I'm saying is, my lord, this...
It's a very novel idea, a good argument which is being involved, but not in the facts of this case. Please.
Well,
the facts, I'll distinguish from the facts.
Well, it may so happen, my lord,
Section 9. Efficacious remedy. On the ground of an alternate efficacious remedy, the Section 9 is dismissed.
Ajay, you haven't filed a 36? That's what I'm saying. But
Mr. Sinha, it is only if suppose you have filed it when the award is passed within 30 days of the award to protect whatever has been given in the award. I still understand that an interim measure is required for that period. You wait for more than a year. Forget about the nullity of the award. Forget about, unilateral award. All that you forget it. Just to maintain your Section 9. since it is an interim measure which has to be granted pre, during, post, and all stages, what has to be seen? Prima facie, balance of convenience, irreparable loss. And this is only to protect you in terms of the award which has been granted, not for 34, not for 36. I know why it has been filed. It's all right. I'm not getting into it.
Lordship not feels that because it has become enforceable, therefore.
Enforceable than 36. Don't use that word.
That's what I said.
Don't do that. The moment you say it has become enforceable,
No, I'm asking.
you're shooting in your own foot.
Not enforced.
But I'm saying, I'm wanting to
My lord,
understand.
I am saying it's not enforced.
No, we have not enforced. No, that's.
Well, that is not enforced since when? It's an award of 10th of November 2025. You're filing a section 9 for what? Interim protection. That before it is enforcement can be done in 9. You are seeking an interim. Wait a minute.
Absolutely.
Interim protection that secure me till the time I file my 36. Eventually, you have to file your 36. This is only interim. You are seeking interim protection in terms of your award. Execution will be done in 36. Can you execute in 9?
No.
We can.
Then execution will be in execution.
Then
obviously I can't enforce it.
Then ultimately what will happen?
Actually.
Ultimately what will happen?
Ultimately, my lord, when I come for execution, your lordship will, my lord, deal with the award, my lord, as
Mr. Sen.
No, your lordship will deal with the
Mr.
award.
Sen. Okay. Well, how will I deal with the award?
As your lordship has not in
No, not me. What is unilateral? What is the outcome of a unilateral?
It will be made a nullity.
It will be held to be, my lord, unenforced.
Nullity.
It will be
The
held.
mandate will go.
Then you earn interest.
No, my lord,
What do you get?
no, mandate will go. My lord, your lordship has also said that you can de novo start the proceeding.
Correct. That's what I'm saying. I'm saying, what do you get?
My lord, when I get that interim protection. My lord.
That's what.
Interim protection. My lord, that's the only thing.
It's the interim protection if 34 is not filed. That period, if you would have come 10th of November in December, if you would have come, I can still understand that yes, you need that interim protection. Why today?
My lord, may come back on Monday, my lord. If
Yes.
just to
Why
not consider this point,
My lord, on this point, my lord, we'll
After
just,
1 year,
my lord, on this point, let us, my lord, come back on.
who's stopping you from enforcement?
My lord, no, my lord, I have, my lord, told your lordship. I have told your lordship the difficulty faced and my lord,
Section 9, no, what is the meaning of section 9?
my lord, the interim
Interim protection.
no, my
what?
lord, it's preservation of the subject matter
Why?
of the
Why?
arbitration.
Why is it interim? Interim measure is
Yes, my lord. Because, my lord, till the time it finally culminates into the,
exactly.
my lord, that's where I'm saying that if I have to restart the process again, in the meanwhile,
Get an award and come after 1 month.
yes,
Prior to that.
yes,
15.
I've understood. I've understood factually what
Makes
your
sense.
lordship has said. Factually what your lordship has said. I've understood. Factually. Yes. But let us come back on Monday, my lord.
Thanks. At least have good facts to
Yes, my lord. I have understood, my lord.
stand on your
My
leg.
lord, I have understood that your lordship is, my lord, distinguishing this on facts and saying that, my lord, your lordship
And I'm
can...
not saying 9 is not maintainable.
No, I know, my lord. I have
Well,
your
whole
lordship.
9 is
I
maintainable.
have your lordship's judgment also on 9 being maintainable.
Absolutely.
I've taken that out.
I will
But
hold.
only, my lord, the difference, my lord, which I've seen is this factual aspect.
Absolutely.
That I've understood. Your lordship wants to reject the section 9 on merits because of these factors. Your lordship is saying.
Absolutely.
That I've
I'm
understood.
not saying 9 is not maintainable. 9
Well,
is
but this judgment, my lord, to that extent, my lord, it does answer, my lord, on the legality of it.
But I'm not on 9.
I know your lordship is on the facts saying that you've come so late.
The facts of this case.
In the facts of this case.
In the facts of this case.
Facts of this case. But I can only make an endeavor.
No, you did a good job. I'm not saying that, Mr. I'm just saying that in the facts of this case.
Yes, well, I'm making an endeavor. Well, in the facts of this case also, well, I was trying to make an endeavor. Well, that's why, well, I did not place the facts first. I, well, told your lordship because I know what was troubling your lordship.
That's why I was telling Mr. Sen, not in this one.
Not in this one.
You get better ones.
That's what he's.
Lordship not keeps these matters not on Monday, but I'll
Yes, you get better ones. You know, we'll.
Yes, but I've understood what your lordship said. Not this not item.
But ultimately, how will it help your client?
My lord, I'll tell your lordship, my lord, what happens is, my lord, if we,
Ultimate.
yes, ultimately, my lord, once the process starts de novo.
Sometimes it's settled also. That's what. Sometimes the matters get
My lord,
settled.
if it starts,
not the matters. No, we're only interested in what we have learned.
We don't want anything
My lord, when it starts de novo also.
To start the process.
My lord, what if in the meanwhile, my lord, what can happen in the meanwhile is if the asset is sold or anything of that sort. That's the only apprehension.
These are only bank accounts or something.
My lord, they are, my lord, at distant, my lord, the
Ability will be the same way.
well, that's the thing. Only that extra protection, a little bit of protection which comes on the way. Well, that's the only thing. The process, my lord, obviously, my lord, will be restarted because, my lord, ultimately, an arbitration has to end with the passing of the award.
I saying maybe in 1 or 2 cases it can get settled like this, but something contrary, absolutely contrary to law, to get that enforced, the other side is again not a foolish. They will also understand what exactly is there. The law is against you as far as the unilateral.
None of the matters, not we insist on the award. Not we always say pay as per the agreement, we'll settle. We do not want the awarded amount. Just give us the amount as per the agreement with reasonable interest, not we shall settle. Not everybody takes advantage of the technical points, not
But the law is such. Today, the law is. You can't either you get that altered or the legal.
My lord, that is what, my lord, that is why I'm saying that if the process restarts also, my lord, at least, my lord, this much I know that the asset is secure.
Now, even the 2025 latest judgment also of the Supreme Court, it's categorically states there's no question of all these unilateral.
On the unilateral, yes.
My lord, we are not, my lord, that
I'm just saying it all arises out of that only.
Absolutely, my lord, absolutely.
That is the father.
Yes.
All are the offsprings.
Yes, my lord. That's true, my lord.
No,
That's what I'm saying, my lord. That is where, my lord, I was saying that if it restarts also, only additional little bit of protection is that it is, my lord, secured. That's the reason. I understand, my lord, in the facts of the case, your lordship is saying in this case.
So the case
My lord, we'll try and figure out.
My order will be set aside.
My lord, what we are trying to do is, my lord, we are trying to figure out, my lord, there are quite a few of them. My lord, we'll just figure out with what has fallen from your lordship.
May I give the list? May these matters appear on Monday, I'll in the meantime check.
Yes.
Now, I just see the serial number. Lordship, check.
49, 55, 57, 65.
49, 50, 51, 52, 53, 54, 55, 57.
Okay, 49 to 55.
To 55.
And then 57, 65, 68 to 71, and 73 to 71. Yeah.
But I've given to both.
Grateful to you, lordship.
On Monday.
My lord will not take me on this. My lord, I had to, my lord, obviously
will I?
try and persuade your lordship on the basis of this.
Absolutely a pleasure to hear you and to get a different perspective.
Yes, sir.
I'm not stuck with any.
No. My lord, I know, my lord. Your lordship said if I had a better case, my lord, if I take it out, my lord, then perhaps I'll be able to.
Absolutely not
On facts, my lord, if I can come up with a better one. Grateful to your lordships.
I'm open till the last minute.
No, my lord. I know, my lord. That's why, my lord, I took, my lord, that liberty, my lord, of trying, my lord, perhaps, my lord, if I may try and persuade your lordship on this. My lord, showing the difference between the 40 Act and this Act. And, my lord, how it has been, my lord, interpreted.
Next time.
Very good. Grateful to your lordships.
Yeah, done. Yeah.
Item number 58.
58, madam, I'm for the petitioner. This is my section and application.
I'm appearing for the respondent in this matter, Mr. Lahiri, your lordship.
Where is he?
Mr. Siddharth is appearing with me.
Where is he?
Lordship, I'm praying for accommodation for the.
Mala, this is my section and application, my lord.
Application,
I'm seeking injunction. my lord.
Instruction even yet, your lordship. I have sought for instruction, but we have not received any instruction.
I am suffering, my lord. My
What instruction have you sought?
Your lordship, regarding the subject matter, your lordship, we have sought for instruction, your lordship, but till date we have not received yet. That's why I'm praying for an accommodation, your lordship.
He said he's not going to encash it. Last time it was there. This matter was there, right?
my lord, what happened in this matter, my lord, that I'm the successful bidder of.
No, you're
Yeah.
seeking the restraint of the performance.
Yes, my lord.
He had made a statement that he will take instruction from the client. And
But
they are not contemplating the encashment of the bank guarantee.
My kindly see, my lord, what they have actually written to me. Yes.
But if that issue can be resolved, then there is nothing here. That's the only thing which you are seeking, correct?
Yes, my lord, because we want them not to encash actually.
Let them come back with the instruction.
Can you give us, my lord, at least fix the date, my lord? So that
I will.
yes, thank you. And my lord, one more liberty, my lord, indulgence, my lord, because we want to file a supplementary affidavit because after filing
Bringing on
this,
record what?
being a record, my lord, because after filing this application, we have also come to know from the NIT Durgapur, this partner, that this work that we have done is completely satisfactory. This is the further reconfirmation of the report, my lord. So we want to bring a record, my lord. And secondly, my lord, this contract value has also, I have instructions enhanced and the bill amount is also has enhanced. So we want to bring on record of this also, my lord. Kindly give us liberty to file a supplementary of the next occasion, my lord.
Counsel for the petitioner seeks and is granted liberty to file a supplementary affidavit bringing additional facts on record pertaining to the present petition. In a period of 2 weeks.
2 weeks, my lord.
List after when?
Your lordship, kindly 2 weeks, your lordship, grant me time.
After 3 weeks.
Oblige, lordship.
Don't do anything.
My lord, notice of motion, my lord.
I'll take instruction regarding.
I have to file a notice of motion, my lord. This is on record. Yes. Can you record it? Much obliged, my lord. Right.
Parents are there. Parents are there.
My lord, item 15, my lord, I beg to appeal for the petitioner, my lord. My lord, this is in section N application, my lord. My lord, during the pendency of the section N application, my lord, we have filed in section 11 application, my lord. My lord, if, my lord, I'm praying if the both, that is not listed yet, my lord. But if, my lord, both be heard together, my lord, so my lord.
On the other side.
I'm for the respondent.
You're for the respondent. We'll allow the section 11. We'll keep it day after tomorrow.
Lordship, only difficulty is, Lordship, that there are several facts. The matter was compromised in the court. It was compromised in the proceeding. They took the half of the jewelry, they took half of the money. So give me just 2 days time because I'm led by. Today I'll come back, Lordship.
You are led by. You can do it.
I'm saying I'm taking care of this criminal proceeding also going on. So
This also you can.
kindly keep tomorrow, Lordship.
My lord, tomorrow I'm not there, my lord. My lord, can it be
Yeah,
on a
after
Wednesday,
tomorrow.
my lord? Yes, thank you, my lord.
Screen guy.
My lord, section 11, my lord, be listed, my lord.
Day after
My lord,
tomorrow, give the
Yes, my lord, I'm.
section
Yes, my
11.
lord. Yes, my lord.
Lordship, one indulgence, Lordship, can it be on Monday? I have to go to Bihar for a marriage.
My lord, I'm led by Mr. Ghosh, my lord.
Monday.
My lord,
11
Monday, my lord. No problem. And my lord, section 11 has also been filed. I'll
I'm
give you a
keeping that. I'm keeping that
officer.
also.
Yes,
on
yes,
Monday.
my lord. So
Obliged,
did you. So did.
Do to Monday.
59,
Get your instruction to the
Yes, sir.
appointment of the arbitrator. We'll dispose of both.
Yes, sir.
Ishana কোথায় আছে?
My lord, I am appearing, item number 62, 64, I am appearing for the petitioner. I am praying for not to there.
Why?
Learned counsel in this matter, due to medical emergency, they will not come. Court.
Not today.
64.
60 to 64, not today. How many scores?
66.
দেখছি। I now 66. 66. Order on you. Huh?
Yes. I appear for the petitioner. This is my application.
I have instructions to appear for a party, but my lord, I don't see, my lord, that because the petitioner is in liquidation. I'm the member of the suspended board of the petitioner who has gone into liquidation. There were prior applications under section 9 where the suspended board was included as a party.
Lordship, I will indicate the facts. Your Lordship, the company had filed an application, Section 9 application earlier, and the receiver was appointed. Thereafter, Your Lordship, several RPs were changed. The company went into CIRP first, then the resolution professional was appointed. He was pursuing these applications. Thereafter, when the records came to the liquidator, Your Lordship, the liquidator pursued the AP. The AP
got dismissed due to unavoidable circumstances, Your Lordship. We have also filed an application for restoration of that AP. However, since the receiver was appointed, the RP and the liquidator have written several letters to the receiver saying that you should hand over the iron ores which you have taken in terms of the order of this court to the liquidator or the RP. However, that has not been done, Your Lordship. So I have filed this application seeking that the receiver may be directed to hand over the iron ores to the liquidator because it is the part of the liquidation estate, Your Lordship.
I am not aware. I have not
Led by Mr. Thakur,
because
Your
not
Lordship.
in previous occasions.
Lordship, sir.
Come back on. Monday.
67.
My lord, I am appearing on behalf of the respondent, but we have not received any copy of this application yet.
Who's for the petitioner? First time, order sheet.
This matter first time is taken up.
Any idea if arbitral proceedings are going on?
Yes, sir.
Arbitral tribunal constituted?
Yes, my lord.
No, arbitrator has been appointed in this matter.
Actually, we have no instruction regarding this matter. So, firstly, instructed them to serve a copy of this application. Firstly,
No, but do you know if the arbitral proceedings have started or not? Any idea? None for the petitioner, dismiss for default.
Dismiss for default.
$72.
Right now 72.
My lord, I'm for the petitioner. I'm praying for not today. We have pleaded.
Why?
The council is busy in some other court, my lord. Much.
76.
Motion adjourned section 9. Right now 76.
I know. Or and what?
With 77.
None appears for the parties. In the interest of justice, adverse orders are deferred. List after 4 weeks. Okay. Supplementary. Keep it in the monthly list. Why they are not here? They mention it. Why should I keep it? With 77. Both way you go. None for the parties in the interest of justice. So also monthly list.
Separate order. Okay. September.
Separate order करना.
Separate. $78.
Yeah. This is what default. None appears for the party. None appears for the petition. What is it? है क्या ये सेक्शन 9 है 11 है 9 है Last time also nobody had appeared. एक मिनट दिखाना ये order sheet दिखाना. Order sheet. Order sheet पे लिख लेना. Even on the earlier occasion, when this matter was listed, i.e. on 13th April 2026, there was no appearance on behalf of the petitioner. Today also none appears on behalf of the petitioner. It seems the petitioner is not interested in pursuing the present petition. The same is dismissed by default.
This was 24. 79. I appear on behalf of the respondent numbers 1 to 5. Your Lordship, this is a matter. Your Lordship was hearing the Section 11 application. Mr. Shako Sen was leading me and Mr. Lakmani was there. Your Lordship had given us the liberty to come back with the Wakalatnama. Your Lordship.
Yes. Oh, yes.
It listed on the 26th. Kindly keep it after
This
that.
is that Wakalatnama
Yes,
from
that matter only.
abroad.
My reference are not appearing, but it will be unfair because if they were proceeding in Section 11. Kindly keeps it after that. It's supposed to be listed on 26th, Section 11.
Okay. None appears for the petition. In the interest of justice, adverse orders are deferred. Let this matter be listed on September. We'll give it a
Your Lordship.
monthly list.
I'll leave it up to Your Lordship. Grateful.
Yes.
And now wait. And now 80.
Same order. Monthly list.
Monthly.
And now 81.
80, Lordship, I'm for, in 80, I'm for the petitioner.
80.
80.
Yes.
Lordship, nobody appear for.
You argue your case? Where's the file?
Special file करो.
What's the matter?
Lordship, this is a Section 9 application.
So, where are who's doing it?
Lordship, I'm led by Mr. Tilak Bose.
Proxy counsel so and so appears and prays for an adjournment on the ground that she's being led by learned senior counsel Mr. Tilak Bose. List after what, 2 weeks? When do you want? 2 weeks?
As your Lordship, please.
After 2 weeks. Give a date after 2 weeks.
I'm grateful. Lord.
2 weeks. Okay. तो आपका नाम क्या देवें?
Next. Give your name, madam.
आपका नाम?
81.
Your Lordship, I'm for the petitioner. Kindly withdraw the matter.
Learned counsel for the petitioner seeks to withdraw the present petition with liberty to file.
This is
Yes.
82.
Lordship, I'm for the petitioner. We have filed a Section 11 application where the arbitrator has been appointed. We shall take further instructions and come back
What for the instruction?
from the client and proceed for the arbitration.
Yes, so withdraw this.
If your
Right,
Lordship,
Section 17, learned counsel for the petitioner seeks to withdraw the present petition. Learned counsel for the petition with liberty to file appropriate proceedings.
grateful, your Lordship.
83.
Your Lordship, in this matter, Mr. Ritesh Kumar Ganguly is appearing. Yes, I'm informed by his clerk that due to some medical reason he could not appear today. Your Lordship,
Today,
Lordship, he was praying for not this week. He would not be.
this week.
Yes. Grateful, Your Lordship.
84.
appearing on behalf of the respondent 113, Your Lordship.
84, who's the petitioner? None for the petitioner. Dismiss for default.
84.
There in 84.
Yes, my lord, I'm in 84. My lord, due to technical glitches, I'm not available with the virtual mode.
All right. Due to learned counsel for the petitioner states that due to technical glitch, she has not been able to join the virtual proceedings. She prays for an adjournment. Let this matter be listed in the monthly list of September.
No, my lord, it's not possible for the back release, my lord. Kindly take up any day at per your convenience.
You argue now, I'm taking it today. It's just that I can't see you. Argue, madam.
No, then my lord, not today, my lord.
The monthly list.
Your lordship would recall this is the matter which your lordship would express that should be sent to arbitration. And with all the issues open. So they have not expressed any urgency since then, so it might stand over to the next monthly list.
Monthly. Give your name, madam.
Oh, Shah, my lord.
O Shaha.
Hmm.
Means O. Put it in the chat box. Put your name in the chat box.
Much obliged, your lordship.
Mosha, MOU. ये लिखा है.
Mosha, MOU. 85.
In 85, I appear for the respondent, my lord. There is an application, my lord, under section 14 filed by the petitioner. My lord, it was conjointly taken up, my lord. There was another application under 29A, my lord. Mr. Sen, Shakko Sen was appearing on the other side.
Where is he?
No, my lord. They have not been appearing. It's the second occasion, my lord. Mr. Sen is not there anymore in the matter. There was another set of advocates appearing.
And for the petitioner, in the interest of justice, adverse orders are deferred. When is the other matter coming?
Well, that has been disposed of by your lordship. They've gone up in before the Honorable Supreme Court. That has been dismissed. So the tribunal is continuing with the arbitration and they are participating in the arbitration.
What is this they have filed? For change of the arbitrator.
That their application was for change of the arbitrator, my lord.
But they are participating in the proceedings, right?
They are now participating in the proceedings.
Then this application become infructuous.
Effectively so, my lord, but nonetheless, unless they appear, my lord.
What order they are challenged?
Well,
Section 11.
they have not challenged the order per se
which
for
went-
substitution. Well, there was no order per se which was
The
under.
event which went up to Supreme Court. What order?
Well, the Supreme Court, my lord, in respect of, my lord, the 29A application which we had preferred,
They had challenged that.
they had challenged that and that has been dismissed.
Dismiss for default.
Grateful.
And for the petitioner, dismiss for default.
I was also seeking for an indulgence, my lord, item number 78. I appear for the respondent in that matter, my lord. I was here when it was item number 79. Just that, my lord, I didn't.
Dismiss for default.
If, my lord, my presence could be recorded in respect of
All
that.
right, put his presence.
79. 78.
My lord.
78.
My lord, may I make
Samrat.
For the respondent, my lord.
Samrat Mukherjee, right? What's her
78 and
name? No,
85
what's her name?
Joyanto Sengupta, my lord.
Joyanto Singh. Joyanto Singh.
My lord,
78. Respondent.
great. My lord, 76 and 77, your lordship has called.
Thanks to.
My lord, couldn't run and reach, my lord. I am for the petition I have
Run
mentioned.
faster.
I couldn't run fast, my lord.
I ran as fast as I could, my lord.
What do you want?
76 and 77, my lord.
I
Seven,
put it in the monthly list.
my lord, there is urgency. I mentioned.
Every day you mention this matter and
Yes,
you're not
I
here.
was on my way. I was running around, my lord. I was coming, my lord. That's the reason I.
Morning till evening, you trouble me with this mentioning every day. And then you're not here.
I couldn't run faster than that, my lord.
You
From
should
that
be
building
here
to this building.
3,000 crores.
300.
Three what?
Yes.
You know, it doesn't matter. But every day you have been eating.
I have tried, my lord. I've tried to. That's the reason. Kindly, Lordship will keeps it any day, my lord. I was just. This is pure bad. I couldn't run faster than this, my lord.
Should have stayed here. 300 crores. Every day you are.
Yes, some other place, my lord. I am not going to get any day, my lord. Any day.
All right. Just make it not today.
Kindly, my lord, Wednesday, if it could be taken up,
No, next
kindly.
week. Next Wednesday.
Next Wednesday. Obliged.
76, 77.
76.
Just change the order. Next Wednesday. मैंने कह दिया था monthly list.
नामটা দেবেন হ্যাঁ ওই যে মান্থলি চেক নামটা দেবেন
नहीं 12th. 12th office.
Deeply obliged.
ওনারে নিয়েছে
Item number 67, my lord. I was in the code number 8.
Sir.
It was dismissed for department. Kindly making it not for if my lord. I was in the code number 8, my lord. So I will inform.
All right. 67, not today.
I'm grateful.
67 not today 76 77 হচ্ছে 12 তারিখ অর্ডার হলো না তাই তো
না অর্ডার হয়েছে শুধু মান্থলি লিস্ট চেঞ্জ হয়
আর এটা 67 টা অর্ডার
87
ওনার নামটা দিয়ে যাবো 76 77 12 তারিখে 86
Lordship, in 86, I appear for the petitioner. Lordship, in this matter, I'm led by Mr. Abhishek Guha. Lordship, I'm just praying for a not today. Lordship, kindly takes it up on Wednesday.
Not today.
Grateful.
It is 7
My lord, I appear for the petitioner, my lord, in this matter. My leader is appearing virtually. My lord, this case relates to an unilateral appointment, my lord. If any.
Yes, Mr. Sinha.
Yes, Lord. Lord, there are two proceedings before my lord. One is not an appeal from an order passed by the under section 17. The other is under section 14. Lord, what I was submitted to expedite the matters, Lord, if Lordship could appoint someone.
Yes, my lord.
Bar,
From
the
Bar.
claim is about 3 crores and not expedite the proceedings, Lord.
My lord,
So, which one is the 37 one item?
Lord, that is APU, not the APOT 65.
APOT 65. my
Item
lord.
88.
Item 88 is the appeal.
And item Lord 87 is the section 4.
Section 4.
And this is section 14.
My lord.
No, I mean to that.
So I'll pass this order in section. In section 14, and I'll pass this order in section 14 itself.
Yes, yes.
My lord,
yes.
my lord.
And Lord, if it commences, Lord, to Mr. Rajratno Shin, Lord, he's a bar library member, Lord. Rajratno Shin.
Just
Yeah.
give.
My lord, I would be suggesting Aniruddha Vitru, but
It's okay.
if
This is an application filed, learned counsel for the parties at the threshold, at the outset. Learned counsel for the parties submit that the arbitrator appointed in the present petition, the arbitrator appointed in the present petition is a unilateral appointment. Full stop. In view of the judgment of the Supreme Court, all unilateral appointments are held to be illegal. Full stop. In view of the same, learned counsel for the parties pray for a substituted arbitrator to be appointed by this court. With the consent of the parties, this court appoints Mr. So-and-so as the arbitrator
Rajratno Shin, Lord, just right.
to adjudicate the dispute between the parties in terms of the facility agreement dated. What is the date of the facility agreement?
My lord.
In terms of the dispute which have arisen between the parties out of the facility agreement? It is out of the facility agreement.
Yes,
itself.
my lord. Annexure A.
Dated 29th April 23.
29th April
2023. Annexure A, my lord.
First, the learned arbitrator shall enter reference in due compliance with Section 12 of the said Act. He shall be entitled to fix his remuneration in terms of the fourth schedule of the Act or with the consent of the parties. A copy of this order shall be communicated to the learned arbitrator to take necessary steps. Full stop. With the aforesaid direction, the present petition stands disposed of. This one you'll withdraw simply.
But in view of, Lordship may say that in view of the order passed in Section 14,
In view of the order passed in APCOM 263 of 2026, the learned counsel for the petition does not wish to pursue the present petition at this stage.
under Section 17, not with liberty to file before the newly appointed.
At this stage, with liberty to take appropriate proceedings in accordance
newly
with law
appointed
before the arbitral tribunal.
And Your Lordship has not expressed any views on the merits, Lord. Just kindly, Lord.
That I'll put in the वहाँ जहाँ arbitration का है ना, this court has not expressed any opinion on the merit of the matter. The learned arbitrator shall be entitled to adjudicate on the issues of maintainability, arbitrability, limitation, or any other issue in accordance with law. Along with all that. Both. 88 is dismissed as withdrawn. 87 arbitrator appointed. Disposed.
My lord, affidavit of service, my lord.
Affidavit of service taken.
'89, Lordship, I'm for the petitioner. This is my 14 application, Section 14 application, Lordship, challenging the unilateral appointment of the arbitrator. Services.
Who's on the other side?
Service is completed.
Who's on the other side, sir? This is Proteum Finance.
The petitioner belongs to Delhi and respondent belong to Maharashtra, Mumbai. But even violating the agreement, they chose to initiate the arbitration proceeding in
Serve them
Kolkata.
notice so that on Wednesday they can come. All right?
Again notice.
Yes.
This Wednesday or
When do you want? Next Wednesday? Next Wednesday, kar do, not today. Serve them a notice again. If they
because
don't
I have
come,
to
we'll pass an order.
send the notice.
Two,
Let's kindly direct on kindly pass a direction for
none appears on behalf of the respondent. Learned counsel for the petitioner is directed once again to serve upon the respondents within a period of 2 weeks, list after 3 weeks. Oh. The affidavit of service karo, affidavit the order kato. Affidavit of service taken on record. Despite service, none appears for the respondent. Let this matter be listed next week. Finish it.
No problem.
No, 90.
1991 can be taken up. Nobody is here.
Lordship, on the last day, I heard that it's a allegation against a former Chief Justice of my court. And what is the allegation? That he asks for ad hoc money initially and then schedule 4. And second allegation,
This is happening in too many cases with the same arbitrator. Same.
both the two matters, or many matters are there.
Many matters. I've come across matters. I've changed him in few.
No, I will not stand in the way. I have no liking for anyone. Lordship can do it, but when the allegation, so far as these two,
I'm not saying anything, Mr. Banerjee. Not today. Simply none for the petitioner. In the interest of justice, adverse orders are deferred. List in the monthly list of September.
I'm up.
1991 both. New motion, section 3792.
92, my lord, I appear for the appellant. Consistently, the respondent is not appearing. It's a section 37. My lord, on the last occasion, your lordship had granted me to, my lord, issue a public notice. But, my lord, it was my duty to point out, my lord, the advocate has entered appearance in this matter, particular matter. My lord, may I serve the advocate and then come back on the next monthly list, if you'll, my lord. My lord, may kindly give the direction so that I can use that direction and then serve it upon my learned friend for the other side. And kindly keeps it in the monthly list.
Right direction, sir. You have to serve upon the
Not so far as that I should serve.
respondent. You know,
It'll be
serving on the lawyer is not the right procedure. I can simply re-notify it.
then Lord may kindly keeps it in the monthly list of
Learned counsel
September.
for the petitioner seeks an adjournment and requests for the matter to be listed in the monthly list of September. Let this matter be listed of September.
It आगे
Let's see. 89.
Next one.
93.
It's a non-commercial matter.
Lord, item number 93, I appear for the
Nothing today.
Very
Not
well.
today.
Then Lord may kindly
Just make it not today.
not in the non-commercial list, my lord.
Tomorrow.
Yes, grateful.
Lord, 93 appear for the appellant.
Yes.
I appear on behalf of the petitioner, my lord.
This
The
is an
respondent, my
appeal. This is an appeal against an order refusing my praise under section 17. Lord, I had filed the appeal. Lord, in the interregnum, Lord, the award has been reserved. Parties have finished their submissions. Award has been reserved. Lord, I was humbly beseeching for only two observations. That, my lord, all the issues raised in my section 17 will be considered by the learned arbitrator finally at the time of the award. Lord, only to that effect, Lord, nothing else.
This is like literally allowing you 37.
And Lord, the second claim, Lord, the learned arbitrator has imposed costs of rupees 50,000 on us.
I am not getting into it.
Yes.
If you let the arbitrator decide whatever he has to decide, let it simply stand over. Let it come after some time.
Very well.
Or if you want to argue on the merit of it.
Last 3 occasions also, my lord, they have taken adjournments.
You want to argue, let's finish it.
Lord, I made my submissions, my lord, since the award has already been reserved.
No, but
Parties
you
have
still,
made,
you are aggrieved.
Lord, then kindly keeps it after some time, 4 weeks or 8 weeks, my lord, in the
No,
interim.
you are aggrieved. Why should we keep it after 4 weeks or 8 weeks? We'll finish it off. What is that? What are you challenging?
My lord, challenges to an order, thereby.
No, what order?
My lord, section 17, we had filed a section 17 application as the respondent. My lord, my application is at page 381.
Concluded during the course of the Order 2, Rule 2.
No, my lord. My lord, application seeking possession, handing over of possession of the plant. My lord, this was a power plant in which I had issued a tender calling for parties to refurbish the power plant. And then, as per the contract, the successful tenderer would be handed over the plant for 20 years for operation and maintenance.
So you withdraw this, challenge everything in 34.
Yes.
What's the point of keeping this?
Very well.
Learned counsel for the petitioner seeks to withdraw the present petition.
My lord, may I make submission? My lord, kindly does not record this. My lord, I am a government corporation, Eastern Coalfields Limited. My lord, kindly does not record.
I will learned counsel for the petitioner submits that the arbitral proceedings have concluded. The arbitral award is due for pronouncement. Full stop. In view of the fact, at this stage, learned counsel for the petitioner does not wish to press the present petition, but reserves his liberty to file appropriate proceedings in accordance with law if aggrieved by the decision of the arbitral tribunal. Full stop. Such liberty is granted to the learned counsel for the petitioner to challenge the said award if aggrieved by the same. Full stop. In view of the same, the present petition is dismissed as withdrawn at this stage. There's nothing here. I've recorded everything.
Wait for me.
अच्छा अच्छा अच्छा
94. Lordship, I'm for the petitioner. I'm praying for not today.
Why?
The counsel assisting is currently unwell, Lordship.
So counsel is appearing through virtual mode.
Respondent?
Yeah.
Petitioner wants a date, not today.
Grateful, Your Lordship.
I beg to appear for the respondent Willard in 95 and the appellant in 96. That both these appeals Willard have become infructuous. These were from an interim order in section 17. Now Willard, the final order was all passed on, recently passed Willard on 8th of July. Now, therefore, Willard, it has merged with the final order and that has not challenged. These may be Willard dismissed. The rest, I understand 90
95 is their challenge, huh?
there and 96 is my cross appeal.
All right, 95 dismiss in default, and in 96 you want to withdraw.
Yes, Willard, because this has become infructuous.
95 dismiss in default. 96 learned counsel for the petitioner seeks to withdraw the present petition since the same has become infructuous. The present petition
By an order dated 8th of July,
by an order dated 8th of July, infructuous.
the section 17 was disposed of.
8th of July, date 26.
26, sorry, 26. 26. Great.
Dismissal withdrawn.
My lord, this is my application under section 37, my lord, from order of interim order passed by a unilaterally appointed arbitrator, my lord. My lord, the section 21 note.
For the respondent, we don't have any issue if an arbitrator is appointed since they have challenged this appointment.
My lord, that I need to take instruction on that, my lord.
Take instruction so that we can finish it.
Yes, my lord.
We can finish it.
My lord, I need to take instruction from the company, my client, my lord.
Not today. When do you want?
My lord, kindly keep it Monday, next Monday.
Wednesday.
Wednesday.
It's next day after tomorrow. Yes.
My lord. My lord, the affidavit of service may be kept in record, my lord.
Affidavit of service taken on record. Learned counsel for the petitioner seeks an adjournment like this. Had to be listed on Wednesday.
Grateful.
Date date call No. Annapurna Swadesh.
98.
Sorry, 98.
I'm for the petitioner.
What?
Yeah.
Appearing virtually.
But appeal is arising from an order passed by. No, no, brother. It's the appeal order impugned is the order dismissing my application under section 17 regarding the the transaction between the parties was that the petitioners were to acquire some properties of the respondent. Later on, petitioners figured out that the property was not viable, and the
What is
deal.
the state of petition? Is it
We are
still-
proceeding with evidence.
So you want to press this?
I want to praise this for interim protection, because the interim protection, my basic prayer is for gain some security in the terms of money security. Even if the
Section 9.
but Section 9 at that stage will not be filed. We obtained an order of some protective orders, because at that point of time, what was happening is the respondent were encashing our post-dated checks.
Tell me, what is the impunity in the order? passed by
If Lordship permits, I can show that.
Yes, Mr.
My lord, I intend to file an opposition because the prayers really are in the nature of attachment before judgment.
Sorry?
The prayers, my lord, are in the nature of attachment before judgment. I wanted to file an opposition to this application. Am I audible? my lord?
Opposition. Your voice is not clear. Yes, what did you say?
My lord, we want to
Am I
file an
audible now?
opposition.
Yeah. Am I audible now, my lord?
Audible, but in between, your voice is cracking.
And I intend to file an opposition to this application, which is really in the nature of attachment before judgment. my lord.
There are multiple.
It's pending since when?
There is some time, Milord. It's been a couple of months, Milord. 6, 7.
For the first time?
No, Milord. Lordship has heard it once, then Milord, on the returnability, it was not called up. And today, after that, I think Milord, it's June, Milord, I think it was heard. Or Milord, May it was heard before the vacation, and thereafter it is being called now.
What is the GA which has been filed?
But that is the GA.
Okay, GA.
There is a stay application, Milord. Section 37 appeal connected with the stay application. Stay application is the GA. May I place the order impugn, Milord, if Lordship permits, Milord.
Show me.
That's Milord, Lordship would find at page 290, Milord.
290.
290. Oh, no, Milord. Page number
Of the GA.
Yes, Milord, it's volume 2, first annexure. Pagination code नहीं करना.
This is deed of conveyance.
But my mistake, Milord, at page 63. Page 63, my mistake, Milord. Page 63.
So many volumes. Page 63.
Page 63.
Yes.
It arises out of a section 17 application. Application was rejected. The basic underlying facts is that the petitioners wanted to acquire property of the respondent. After executing the agreement, petitioners took the decision not to continue with that deal because it was not commercially viable, and also because the respondents violated the terms of the contract, and accordingly the agreement was terminated. However, in terms of that agreement, some checks were deposited with them, and a cash deposit of 1 crore was made. Now, what happened? After termination, they tried to encash those checks. So we filed a Section 9 application and got a injunction on that. But the 1 crore money which we paid in contemplation of that execution of that agreement is still lying with the respondent. So that is what I am trying a security of because once the contract is terminated, the entire claim of the respondent is now in damages, and my claim in the arbitration proceeding is for recovery of that 1 crore along with the cost that I have incurred. So in view thereof, our prayer for in the Section 17 application was for security of gaining some security in respect of the 1 crore which the respondent received from us in terms of the agreement which is now terminated. Lordship would kindly come to paragraph 2 of the order impugn. Where the land arbitrator has narrated this particular incident which I have just now submitted. The parties have also relied upon several authorities. It is the case of the claimant that
this is the main crux of the arbitral proceeding, that
yes,
1 crore which you have advanced.
Whether I am entitled to get back the money which I have paid in contemplation of an agreement after termination of the agreement.
Seeking that,
I am not asking for a refund. I am saying you secured that money because they are not commercially active anymore.
Crux of the argument, the proceedings before.
But we tried to make out a case that they are not a very commercially viable company, and they may. But tomorrow, if I get an award, That should not become a paper award. I should have the means to execute the award. That's the purpose of the application. That's that. And in fact, the entire asset after termination of that deal, the entire asset was, in fact, the larger portion of the asset was sold to a third party. So they have sold it off and got some money from that. All that we are saying is, since you have now made money out of the same property, you secure my claim and let us proceed to arbitration. In any event, we are continuing. We are in the evidence stage. Our second witness is on the board. So this is kindly thereafter come to the learned arbitrator while adjudicating the issue kindly come to paragraph 13 where the learned arbitrator has sought to give the reasons. The tribunal is adjudicating a commercial transaction where the letter and spirit of the covenant has paramount importance. Paragraph 13. The claimant and the respondent has reciprocal obligations to perform under the business transfer agreement. Both parties had to comply with certain condition precedent. As has been stated above, the parties failed to meet their respective covenants as according to the respondent. The claimant did not make over 20 crore that was required for the conditional NOC from the lenders, whereas the claimant alleges that the conditional NOC was to be obtained prior to the disbursement of 20 crore. On the perusal of just the agreement, it appears the contention of the claimant, though may have some basis, the final understanding of the parties can be assessed only upon further evidence being produced. The present application under section 17 is in nature of attachment to the tune of rupees 1 crore, which was received as part consideration of the BTA. That BTA is that agreement. The court is in its order dated 12th November 2024, while passing the order under section 9, may have made it a condition precedent upon the claimant to deposit rupees 1 crore for a direction that the post-dated checks issued by the claimant to the respondent would not be presented. Such direction cannot be a basis for passing an order in the present application. The claimant tacitly seeks to draw an analogy from such direction issued in section 9 application for reliefs akin to attachment before judgment in the present proceedings. The advance of rupees 1 crore being part of the consideration of the business transfer agreement cannot be directed to be secured by the respondent at this stage, in as much as the claimant has failed to establish circumstances which would suggest that the respondent is financially in a perilous condition. The claimant has indicated that the respondent had made a statement in its reply to the section 17 application that it is not dealing with any of its assets. However, subsequently it has been brought to the notice of this tribunal that the respondent had transferred such assets. Merely transfer of such assets, which was the subject matter of the business transfer agreement, cannot be a ground for seeking attachment of rupees 1 crore, especially when the claimant itself terminated the agreement and is in no way seeking specific performance. The claimant today cannot prevent such transaction. At the highest, the claimant has a money claim, which by exercise of power under section 17 cannot be converted into a secure claim. In light of the aforesaid, the tribunal declines from passing any orders in favor of the claimant in the section 17 application. The application thus stands dismissed. This is the reasoning provided by the land arbitrator that one, there were reciprocal promises. Although I may have a case, but that has to be proved through evidence. That is one. And secondly, only because the section 9 court, while passing order of injunction restraining the respondent from encashing the checks, that asked me to deposit 1 crore, to keep 1 crore as security for those checks. That cannot be analogy for the respondent to now secure 1 crore, which it has received from me. And the third reason provided is that my claim under the agreement is a claim is not a secured claim, and therefore by order of court, that by order of section 17, that unsecured claim cannot be made into cannot be converted into a secured claim. These are 3 reasons provided. Now, with deepest of respect, I will try to establish that I have from the contract itself and from the interaction between the parties, it comes out that the respondent has the reason for termination of the contract is a default of the respondent. When the respondent is in default, there should be some.
It can be seen only at the time of evidence. This is the reason why.
That's the reason. That's the sole reason. That's the major reason provided by the land arbitrator.
Obviously.
It's a contractual dispute. By evidence, how far can I prove something which is not there on paper? My case, it's a black and white. I have terminated the contract. It's up to the respondent to prove that they have a claim in crores on account of damages, that because of termination they suffered loss.
Let them file their reply.
Very good. They let them not
Learned counsel for the
Great.
petitioner
if it
is challenging the order passed by the order dated 8th December 2025 passed by the learned sole arbitrator under section 17 of the arbitration consultation act. Learned counsel for the petitioner contends that the said order is illegal. It said that the states that the order passed under section 17 is without any application of mind, and that the learned tribunal has failed to secure the interest of the petitioner. Full stop. Learned counsel for the respondent states that seeks and is granted 3 weeks time to file his affidavit in opposition, reply to the same if any within 1 week thereafter, list after 4 weeks. GA1 is an application filed by the petitioner. Where's the prayer clause?
But should be one minute. Prayer portion. My prayer portion is at page 47.
Seeking security to the extent of rupees 1 crore as part consideration received by the respondent from the petitioner in terms of the business transfer agreement. Dated, what is the date of the business transfer agreement?
That is undated of February 2024.
Dated business transfer agreement.
That has page 115.
Full stop. Learned counsel for the respondent seeks and is granted. Again, 3 weeks time to file his affidavit in opposition. Reply to the same if any within 1 week thereafter. Do you want to file a composite or you want to file a separate?
But I file a composite, my lord.
Composite appeal to application.
There is only one application.
There's
The
only
other perhaps
one-
is the memorandum of appeal.
Yes.
So
There's
my
one appeal, there's one application.
So my lord, on the application only, my lord.
On the application?
Yes, normally we don't file in the against the memorandum of appeal, my lord. No opposition is filed.
Application में लिखो, he seeks and is granted. 3 weeks time to file his affidavit in opposition. Reply to the same if any within 1 week. और जहाँ पे वो appeal है ना, उसमें दे बस लिख देना. He has filed an appeal challenging the order dated so and so. बस, that's it. कुछ मत करो. Round 1 कुछ मत करो. एक line.
Lord, only affidavits, my lord, because I was not here, my lord.
Only affidavit?
I'm deeply obliged, my lord, because lot has to be said, my lord. And the matter proceeded substantially, my lord. It's towards the end, my lord. It's nearing the end. I'm deeply obliged.
This will become infructuous.
My lord, the claim might be dismissed, my lord. It's my lord, and who had, my lord, terminated the contract by saying that I intended to purchase initially, then we have decided not to go ahead with the transaction. So the money was forfeited, my lord. Anyway, my lord, we will file an opposition.
Yes,
99.
99 is an appeal filed under challenging an order passed under section 17. Last order was passed on 8th of April, my lord, when they took an adjournment saying that they would try to settle. We have not received any offer of settlement from them. We wrote them letters.
What is the stage?
My lord, arbitration continued, my lord. They stopped participating after some time. Arguments have been concluded. And my lord, the award is reserved, my lord.
Dismiss for default. None appears for the petition.
I'm grateful to my lord.
Dismiss for default. GA along with the application.
I'm extremely grateful to my
100,
100, Mr. Priyanka Sir appeared for the petition.
Not today.
100, 101, 102, 104, 105.
Why you are taking dates every
Well,
time?
he is engaged with the code number 16, my lord. Otherwise, my lord.
101, 2, 3.
Except 3, my lord. Up to 6, my lord. 106.
4, 5 and 6 I appear for respondent.
4, 5, 6. Not today.
Yes, my lord.
Call out 103 then.
103.
Not Jawaharlal.
Not sure.
Not today.
107.
Your Lordship, I'm appealing for the appellant in this matter. This has come up for the first time. I'm being led by Mr. Shomapu Ghosh.
Not today.
Kindly grant an adjournment. Obliged to Lordship.
108.
108. May I please, Lordship? I am for the appellant, my lord. It is an appeal under section 37 of the Act, my lord. Appointment of unilateral arbitrator, my lord, beyond the jurisdiction. Also, the point has been taken.
Instructions in this matter. Praying for not today. We will
Last
come back
occasion, your lordship allowed some time to my learned friend for taking instruction, my lord.
Yes, why did you take instruction? We'll set it aside. Unilateral appointment.
Order, my order has been passed in the section 17 application as if in the final order.
One day accommodation. Kindly grant 1 day accommodation. We will come back with instruction. We would also like to expedite the matter, but
Wednesday.
My lord, can it be passed in a stay of the impugn if my learned friend has not
Yeah.
proceeded? Impugn order and execution if they fight.
1 day, and in that case, if we can
I'll set it aside
pursue, if we
itself.
can.
Why?
Yes,
Stay
my
or
lord,
ask?
my lord, my lord, my lord, my lord. All right.
Not today.
Wednesday, your lordship.
Wednesday.
Wednesday. Keep your lordship. Grateful to lordship. And 9 also. 108 and 109. Same order. Much obliged.
110.
Lordship, I appear on behalf of the petitioner. I am praying for not today on the grounds of counsel not being
Not today.
grateful, Lordship.
111.
I'm appealing for no.
Not today.
112.
Lordship, 112, I'm praying for a not today, Lordship.
Why? Withdraw.
I mean, led by Counsel Mr. Devraj Shahu in this said matter and Mr. Abhishek Banerjee, Lordship.
We are for the respondent, my lord. This is a 37 filed by Hal, my lord.
She's saying that.
My lord, she is my junior, my lord.
Oh.
My lord, 37, my lord. We appear for the respondent, my lord. Thereafter, my lord.
Who appears for the petitioner?
My lord, Miss Abdo, Nilanjana Abdo appears generally, but this appears from a 17 appeal. 17 injunction on bank guarantee. Thereafter, they.
So where is he? Dismissed for default. What do you think?
Whatever your lordship pleases, my lord.
You want that?
But the arbitration has arguments has been concluded. Award would be passed immediately.
Dismissed for default.
Lordship, I appear for
Who's
the petition in
Petitioner.
this matter.
Very
Yes, your
good.
Lordship.
I was just going to dismiss it. Yes, Mr.
Lordship, I'm sorry I couldn't appear in person
Yes.
because of the rains.
You are lucky that you're not here. Yes. Yes, Mr. Datel.
Lordship, this is my application.
Yes. Proceedings have already concluded
an
before the
appeal.
tribunal. What is left?
Yes, your Lordship.
Why you want to pursue
We have
this?
been
Let
informed
the
that
award
the
come.
proceed.
Let the award come. You
Lordship,
challenge
in
everything.
any event, your Lordship, the award. Yes, your Lordship.
Then you
As your
withdraw.
Lordship pleases, your Lordship may kindly Lordship may kindly pass an order, your Lordship, in that case, because we will.
No, then I'll say that you want to withdraw because the award has already, the matter is already stands concluded before the arbitral tribunal and it's listed for pronouncement of the award.
Final arguments have been concluded by the petitioner. The respondent's argument are yet to be.
Still, all right. You come back, Mr. Das, next week. We'll see.
Lordship, I should do that.
Obliged.
It's the previous matter.
I didn't dismiss it.
No, not dismiss that. I'm for the petitioner, my lord.
Yes.
I only want, my lord, affidavit direct.
Here?
Yes, my lord. Just want affidavit direct. It's a contempt. I want the respondents to file affidavit. That's all.
I already passed it over. Somebody was there.
No, my learned friend
No, she was there, but somebody else was also there.
Somebody else was there. Then can't be. Not
I think somebody was there online.
If the other side was there, it wouldn't be right.
I think so.
But I'll.
Actually, I don't know today. What not today? 113.
My lord. 113 to 116, my lord, I am for the petitioner. There is two application, my lordship. Two is for section 36 and two is for 34, my lordship. My lordship, section 36, they have filed opposition and we are seeking 2 weeks time to file reply. And section 34, they have not filed any opposition till yet, my lordship.
Who's there on the other side? So you are petitioner in two.
Yes, my lordship.
Sir, actually, I filed an application under section 34.
Are you petitioner in person?
No, sir. Yes, sir, petitioner in person.
Petition in person?
Yes, sir.
She is mentioning, I think.
Yes, sir.
Which matter?
I'm mentioning for some other case, sir. Sir.
Yes, my lordship.
Not today, we'll see. Not today.
13 to 115. Sixteen also. 117.
Item 117. It's an
Lordship, I appear for this state of West Bengal, Lordship. We have. Okay, Lordship. Lordship, we have not received the complete instructions in the matter, Lordship. It can be adjourned to any other day.
So I'll put it in the monthly, madam. I'll keep it in the monthly list. Learned counsel for the petitioner states that she has been recently engaged in the present matter. She prays for an adjournment and prays for an adjournment so that the matter can be placed in the monthly list of September. List in the monthly list of September.
Appearance term.
808. Oh, I'm appeared for the award holder in the matter.
Yes, September.
Lordship, this is the matter where there's nothing, Lordship, nothing remains in the matter. There's a payment to be made.
What is there in the matter?
Lordship,
Lordship, here this is actually for stay of the award. We had come up, there was an order for us to.
Is a 36 application?
But we had to deposit.
The money.
Lordship, we had to deposit the money. The state went up to the SLP. SLP got dismissed. Now it's come back. We have received the brief last week. Lordship, we've connected with the.
All right, then keep it after 1 week.
Kindly.
With the department.
Strike down the order.
Give me 2 weeks, my lord, to just come back.
All right, keep it. Learned counsel for the petitioner. Change karo. Learned counsel for the petitioner states that. Are you recently engaged?
Lordship, just.
Learned counsel for the petitioner states that he has been recently engaged in the matter. He prays for an adjournment. Let this matter be listed after 2 weeks.
2 weeks, my lord, we'll come back with those instructions.
12th of August.
I'm grateful. I apologize. I could not reach.
Grateful.
Great.
একজন দিয়েছি 180.
Your Lordship, I am for the petition in this matter. The appeal is pending in Supreme Court till yet.
In this matter, Mr. Arijit Bhumik is appearing for the respondent.
Is the matter pending in the Supreme Court?
Yes, Your Lordship. So I think we can't take the return of the bank guarantee unless and until the appeal is disposed of.
All right, not today.
Sir, now can
19.
My lord, 119, I am appearing on behalf of the respondent, my lord. This is a section 34 matter, my lord. It's ready for hearing, my lord.
Nobody is here.
My lord.
19. You're appearing 20 also.
Yeah, 19, 20, 21, 22, 34 and 36, my lord.
What are these matters? 34, 36.
34, 36, my lord.
Fresh.
Yes, my lord. The pleadings are completed, my lord. Mr. Kishore Datta was Mr. Sanjay Saha was from the petitioner side, my lord, and it was ready for hearing.
Nobody is here. Apart from you. You are the petitioner in 2.
I'm for the respondent, my lord.
Respondent. Inform the petitioner's office. There must be new lawyers. Who was appearing for the state just now?
Kishore Datta, my lord. He was Mr.
He
Kishore
is no
Datta.
longer there.
But he was there, my lord. Mr. Sanjay Saha was there, the advocate record, and Mr.
Yes, sir. After the government change, who's there? You find out.
Okay, my lord. I'll duly find it. My lord.
New councils have stepped in.
After my lord, humbly submitting, my lord. After inquiring, I'll inquire, my lord. I'll inquire.
19, 20, 21, 22, not today. No, none for the petition. In the interest of justice, adverse orders are deferred. Monthly September. ये same करो order 19, 20, 21, 22.
Deep level.
September. 119 122 I know 123.
Who's there? Same order करो. None for the petitioner. Monthly till September.
One
124, I am for the petitioner, my lord, award debtor. It's an MSME award, my lord. We are enjoying a stay from 15th of September 2025. Lastly, my lord, on 10th of June 2026, your lordships had extended this interim stay for 8 weeks. That is expiring on the 5th of August. Now, my lord, there is one application. We have already filed an application. My lord, we are enjoying a stay from 15th September 2025. Last extension was on 10th of June 2026 for 8 weeks. My lord, we have already filed an application seeking extension, and my lord, I've been
The
informed.
application listed?
Not listed, my lord. It has been numbered today. GACOM number 3.
Not today. Keep it with the application on Monday.
And my lord, one more, my lord, the respondent, which is the award holder, has filed an application GA2, my lord, seeking vacating of the interim stay. My lord, we have filed the, my lord, we have served the affidavit opposition in that application, my lord. No, very well. My lord, one more thing, my lord, on the in the order of 10th of June 2026, the date of the award has been, my lord, gone down incorrectly. It is mentioned as 20th September 2025. It should be 20th September 2024. Page 3 of the order. Page 2 has the
September 2024.
page 2 has the correct date, correct year. Page 3, the first para has the wrong year. It should be 2024. Page 2, third. Yes.
Or we'll do the correction also
Very
on
well.
that day.
Very well.
Is,
My lord, GA3, my lord.
is new. We'll make the correction on the other day.
Very well, my lord.
Yes.
My lord, GA3 will appear, my lord, on if your lordship is
The file is there, it will appear.
your lordship is making it not today.
Not today.
Not today. Then, my lord, tomorrow it will be low in the list. My lord, perhaps it will be appearing.
इसको थोड़ा up कर देना. Not tomorrow, Wednesday.
My lord, very well then. Then grateful.
Yes, madam, what are you waiting for?
Sir, I have filed a case under section 34, sir.
What is the case number? Why are you waiting to mention?
That is what I'm saying, sir. That is what, sir.
Madam, mentioning is not in the evening. Mentioning is done in the
The
morning.
department is not taking my documents.
Madam, mentioning is done in the morning. Come in the morning. Not
Tomorrow, sir.
Yes.
Thank you, sir.
25 not to do, right? 125.
दिखाना फाइल
125. 125.
all right rest and rest on